Whatever will be the fate in the other matters will cover you.
My lord.
For the petition, I don't know why.
My lord, I just it has come at my instance, my lord, that only because on behalf of school, my lord, the name I appeared, my lord, this name.
Your name has not gone down?
Yes.
Let me
And the
see.
school says in future complications it will be required.
Obviously, it will be required. I understand.
Because in future that party will obviously.
Forget future. Now it will be required. I understand. Name নামটা ঢুকিয়ে দেবেন. Which respondent?
6 to 9.
6 to 9.
এই আইটেম 1 টা
আমার নামটা দেয়নি স্কুলের কারেকশন এই ইনস্পেকশন অফ নেম
6 to 9.
এম কারেকশন এটা যে তোমরা পাঠাও না
আমরা পার্টি তো হ্যাঁ আমরা পার্টি না মৌসুমি
হ্যাঁ এটা অন্য
মৌমিতা মৌসুমি মৌমিতা
Item number 3.
ডান করতে petition.
yes 3
Relating completion of appointment, presentation before the TA, that will be considered. Page my lord 21, 22, 23. My lord representation. Petitioner is my lord total lordship. And the school also my lord made it. Page 22 my lord, the school already. They are already been sent to the PS.
Page 22, there is no date. School.
Page my lord, kindly see. 23 my lord, online my lord, through online.
4/3/2019. 17 September.
Father of the petitioner died in harness on 13th September 27.
Yes.
my lord I have tried to my lord get instruction whether a decision has been taken, but if not taken my lord kindly direct to take
Please come. The petitioners prays for appointment on compassionate ground. Stop. Her father was a teacher.
Yes, Lord.
headmaster
Her father was serving as headmaster of
Mollabpur, page 22.
a secondary school.
Yes, secondary school.
Stop. He died in harness on 13th of September
Higher secondary.
2017. Stop. Application was made seeking compassionate appointment by the petitioner on 16th of
This is on the 16th of July 2018.
no proof of service of this letter.
And thereafter, Lordship, school already been sent, Lord.
লিখুন তো যে the petitioner claims that 18 ওইখানটাতেই লিখুন ডেটের ওই জায়গায় the petitioner claims that application for compassionate appointment was made by her on 16th July 2018, but there is no proof of service of the said prayer before the district inspector of schools. Stuff. The school forwarded the petitioner's prayer to the DI on 14th of March 2019. Stop. There is no response from the end of the DI till date. Stop. Paragraph. Learned advocate representing the state respondents is not ready with proper instructions. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the DI, Secondary Education, South 24 Parganas, to take a decision on the petitioner's prayer seeking compassionate appointment, strictly in accordance with law and the prevailing guidelines at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Step. If the prayer of the petitioner is allowed, comma, the necessary consequential steps shall be taken by the aforesaid respondent. Disposed.
Lordship, I am cited one judgment, Lordship. Married daughter is not entitled to the Lordship compulsory appointment, Lordship.
Very well, let the her prayer be rejected.
Lordship.
I
Yes,
do
sir.
not know whether she is married, divorcee.
Married. He himself, Lordship, stated that I am the married daughter.
Very well, very well.
Lordship.
Item number 4.
Have been taken by Mr. Shuritu Das. My senior is on legs, my lord. My lord, this matter relates to one question, my lord, of SLST 2025, my lord, in environmental sciences. My lord, petitioners have challenged the authenticity of the question because, my lord, there has been the answer which has been given by the commission, my lord. My lord, we think that answer is the wrong answer, my lord, and there is a correct answer which is required. My lord, what has happened is, my lord, in the preliminary answer key, when the answer key was published, my lord, our answer was given as the correct answer, my lord. My lord, when the final answer key was, for that reason, my lord, we could not challenge. There was no scope of challenge because we accepted the answer to be true. My lord, when the final key answer was published, final answer key was published, my lord, the option had changed, my lord. For that reason, my lord, our answer which we had given, my lord, that was and that answer was not taken.
To be correct.
We correct.
All right.
Well, in the preliminary stage, what the answer I gave, the preliminary answer key shows that this is the correct answer.
All right.
Final, they gave two answers, my lord.
Where is that?
My lord, if your lordship first comes to page, my lord, 57.
57, yes.
My lord, C4, serial 4.
Hmm.
Option D is the correct answer.
Yes.
Now, my lord, kindly come to page 59.
This one, page 57, is a preliminary one.
Page 59.
Sorry, that would be Mr. Bandopadhyay's phone.
Yes.
Page 59, my lord, kindly see master 4 at the left hand side.
Yes, B and C.
B and C is the final answer, my lord. And for booklet A and for booklet, it is only the different question number. My lord, for B and final answer is B and C.
And initially it was D.
D, which was marked by yes, my lord. Here, my lord, except every one petitioner has been called for verification, and last three are only 1 mark short of the cutoff marks.
That's probably not true.
My lord, in a similar manner, my lord,
There are.
the lordship has
Sorry, my lord. I am for the system. In this one.
passed such orders, my lord.
Yes. Commission, what will be your stand?
But I am appearing. But the initial number of preliminary objections came from different candidates. Then it went to the expert committee. Expert committee has given the answer that the B and C. Therefore, this is expert committee's comment is binding on us in terms of the rules.
Right. That means your professors or teachers or your paper setters, whoever they are, found D to be the correct answer.
Correct.
Initial stage.
Correct.
That means though they do not know anything. What type of professors are they?
No, that's a different thing. That's a different thing. What type of professor? What is
Because
the
the
standard of the professor?
petitioners,
No, what is the standard of the professor? What the professor is? That's not the.
it is not the standard, sir. The issue is that the petitioner's answer
Shall
and
we go by
the
the in terms of the?
professor's answer tallied.
Shall I go by the in terms of the rules or otherwise?
The professor's answer, the preliminary model answer key tallied with the petitioners.
Correct. But
They did
when-
not have any chance to
my lord,
object.
Similarly, a good number of persons have raised objection on that D. Therefore, we have to send it to the expert committee. That is in terms of the rules.
Certainly, but then at the same time, if the earlier answer, you all are giving marks to questions attempted to everybody. What is and here also you do not have a single answer. You have two answers, B and C.
Yes.
That means, according to the professors, B, C, D all are correct, apart from A.
No. According to the first instance, it was D. According to when the objections came from other candidates, it went to the expert committee. Expert committee said B and C. That is in terms of the rules.
May I, my learned senior's permission, may I hand up how we have worked out, how we have gone through?
No, I do
So-
not think I'll require
Well,
those.
this shows itself the
Because
question is ambiguous. When a question has three answers,
I really fail to understand. Somebody says, and they are certainly experts, otherwise they could not have set the question paper. The person who is setting the question paper is definitely one of the experts, no doubt. And then you receive objections and you change yourself to B and C and the D goes out.
But this
Very
is
strange.
expert's opinion. This is expert's opinion. I cannot do it on my wish. My opinion has been overruled. So I have to go by the expert opinion, and this is for all the persons, not any single individual.
Yes, this I understand. It is not for a single individual.
Whether my lord, I will follow the expert opinion or my opinion, that's the point, my lord. In terms of the
Yes.
rules, I have to follow the expert opinion.
You're right.
I have nothing to do. I cannot do anything. I have, my lord, the moment it is under the rules, experts are being constituted. My hands are tied. If they say, I have to go by that. If the expert opinion is wrong, that's a different challenge. If the
Now-
expert opinion, my lord, if the expert opinion is wrong, if they prove it, I am not going to contend anything. Let them prove that let the expert maybe made party, let the expert says, I have nothing to say.
so the question
I
is
have, my lord, I have nothing
right
to
or
say about the answer. The moment, my lord, I have published the answer keys. On the preliminary objection, so many objections are coming for so many questions. So I have to refer it. I cannot take the decision. I have to refer it to the expert committee. Now, I have kindly appreciate that my opinion has been overruled by the expert committee. Expert's opinion. Therefore, expert opinion is binding on me.
Why will a student be penalized? Not student over here, candidate, be penalized if the answer he has given tallied with the answer of the paper setter?
Milord, that is the reason, Milord. Milord, 98% raised objections, more than one answer correct.
What type of question is your paper setter setting? That that the question has so many answers.
Milord, earlier they could have come that the question was wrong.
No, they did not, because the answer tallied.
No, they did. Milord, question is wrong or right, Milord, can the court go into that questions?
The court is not going because your paper setter said it is
Milord,
right.
your lordship is saying that the paper setters are wrong. Professors.
Your expert is saying.
Milord, my expert, they are my professor. They are my teachers.
Yes.
But above all, the expert is there. Milord, there are levels. There are different levels.
my lord also have
Now the court has to consider to engage expert over experts, which is
But
not
that-
permissible in the rules. And the court does not want to venture into that thing because this is going to open up a Pandora's box.
Milord, I leave it to your lordship. Milord, my opinion has been overruled by the expert.
my lord firstly my lord
Milord, in that case, I will, if you will lordship Permit, I will I am having a suggestion. If your lordships permit, I will give that.
Yes, please.
Let them experts be made party.
No,
Let
no,
the-
no, 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 certainly not.
How can I decide?
I will not
Or
say
your
that.
lordships can, or your lordships can, subject to your lordships permission. Lordships can direct that the expert will take it, will revisit the things again.
No, there is no question of revisiting the issue. If a question has three possible answers, what has been given in D, I have annexed recognized book. Book is saying D is the correct answer. Some is saying B and C is the correct answer. This itself shows question is ambiguous, then marks are to be awarded for B, C, and D. And my lord, in a similar matter where the initial answer key was correct, this honorable court has granted mark and commissioner has accepted that, my lord. I have given your lordship that order, my lord.
But in that case, everyone was qualified.
Yes, here petition number one.
Here is not that. It's not that. They are all 2 marks short.
No, we are 1 mark short and one
One
has
mark short in
qualified.
only one case. You are doing so many petitioners at the same time. Kindly come to page 119. 119.
119?
Yes, my lord.
Yes.
We secured 65. Cutoff is 67.
2 marks.
2 marks.
Yes.
Kindly come to page 120, 121.
My lord, I tell your lordship how I will come in.
Mr. Sir, will you allow us to argue?
121?
Or only you are the lawyers will be arguing?
65. And 69.
65, cutoff is 65. And the cutoff is 69 and he secured 65.
4 marks.
Next, Millard, one secured, kindly come to page 122, 58, secured, cutoff mark 61. Next, Millard, kindly come to page 124. He secured 55 marks and the 61 is the cutoff marks.
Far off.
Huh?
Yes.
Millard, out of 6, 4 cases is this.
65.
And 2 cases, one short. Right? One qualified and one short. One qualified. One has been qualified and one is short.
Yes.
My lord, firstly,
Somebody who's got 51,
my lord, that page,
55.
my lord, 50.
55 and 61. Page 124.
Page 124. My lord, only one thing, why they have come, your lordship knows persons who are to be called for a verification interview are in a particular ratio. Ratio is 1 is to 1.6.1, something like that. Now, my lord, several candidates, why they have come up, several candidates have been rejected at the verification stage. So, some more candidates are required to be called in terms of, my lord, the ratio to be maintained. They have to maintain the ratio. Now, my lord, in a competitive examination, if I can get 1 marks, I will be placed in a higher pedestal. And those who are 1 mark short will come. Those who have been called for verification, if he gets 1 mark, ultimately in the final stage rounds, my
So
lord, it will
55 and 61, 6 marks
he may not be
difference.
benefited, but the others
Right.
are benefited, my lord.
Then those who will not be benefited, or there is hardly any chance of being covering the cutoff mark, then those candidates will not be given marks.
Man, this candidate may not be given marks, my lord, but all others
Ram
are either
Narayan
1
Roy.
mark short or 2 marks short.
And this is page 123, 2 marks short.
Yes, my lord, he can.
No, Ramnaran 63 has qualified.
Yes. My lord, page 120 kindly comes.
123 has qualified.
My lord, 120 then.
58, 3 marks. 1
20.
1 mark, 20. Mampi De. And please come. The petitioner has participated in the recruitment process for appointment of assistant teachers in second SLST 2025 for classes 11 and 12. Stop. In respect of one of the questions in the written test, the preliminary answer key, which was published, tallied with the answer given by the petitioners. Stop. There was no reason for the petitioners to raise any objection at that stage. Stop. At the time of publication of the final answer key, comma, the answer was changed. Stop. Two answers were found to be correct, but the answer given by the petitioner was not found to be correct. Stop. The petitioners are aggrieved by the same. It has been submitted that as the preliminary answer key and the answer given by the petitioners matched, it has to be taken that the said answer be also treated as correct. Stop. The petitioners rely upon study materials. Where are those study materials?
My lord, this starts from page
Page?
66, my lord. No, page 82.
You annex them?
Yes, my lord.
Acha. The petitioners rely upon study materials in support of the submission that the answer which was initially published in the preliminary model answer key is also a correct answer. Stop. Prayer has been made to treat the said answer given by the petitioner as correct. Stop. Paragraph. According to the commission, comma, the commission, several objections were received and the same were forwarded to the expert committee, who opined that two other answers were correct. Stop. The expert committee differed with the opinion of the paper setter with regard to the correctness of the said question. Correctness of the answer of the said question.
Preliminary answer was also suggested by expert, not by the paper set.
Stop. Next. As it appears that it appears now. It is expected that the preliminary answer key, which was published by the commission, was also prepared by expert. Stop.
Well, that is not correct. That contention is not correct.
Who has given the preliminary answer key?
Under the rules, rule
Yes.
11, under rule 11, under the 11 3, the Central Commission shall appoint paper sitters, moderators, who shall not be below the rank of assistant professor of any UGC recognized college or university.
All right. Expert is the assistant professor of a recognized college or university. Stop. Ki diye shuru bolna? No, it is expected now. As per the rules of recruitment, the preliminary model answer key by the right. Right. Stop. The as the answer of the said assistant professor was found to be incorrect by the expert, comma, then the court then a doubt rises in the mind of the court with regard to the uh, competence of the uh, assistant professor whose um, whose assistant professor engaged by the commission to act as the paper checker. Stop. Next, the petitioners asserts that the answer of the assistant professor is also correct, relying upon certain study materials annexed to the writ petition. Stop. It is an admitted fact that the court is not an expert and the court cannot substitute its opinion in place of the experts. Stop. The only option that is left to the court is to refer the matter to the commission once again to revisit the issue as to whether the answer provided by the assistant professor is proper or not. The commission shall take a decision. Now, if the answer provided by the assistant professor is found to be correct, comma, then the answer provided by the petitioner shall be treated to be correct. Stop. Next. A decision shall be taken by the commission at the earliest. Stop. Next. Paragraph. As the petitioners submit that the process of credential verification is going on, accordingly, as an interim measure, the commission is directed to permit. How many marks short is petitioner number 1?
Position number one mark. One mark.
All right. Permit the petitioner number 1, petitioner number 2, 3. How many marks?
No, 3 not. Did it that work? এখান থেকে বড্ড ছোট করিস তুই, এত ছোট।
Petition number 3, my lord, it's 50, 65 and 69.
4 marks short. Cannot be given. 4.
4, my lord, 3 marks then.
3. 5.
1.
1. Kali 5.
No, 5 has already been, my lord, called
Oh,
for.
5 has called for interview. All right. And 6 doesn't get it. All right. Kali 2 jon. 1 and 2 to 1 and 2. 5 has got 3 marks short.
Yes, my lord. 5.
Acha, 5 ke diye dein. 5 in the
3 marks short.
verification verification process subject to the
3 marks short.
report, no, not report, opinion of the expert committee, not expert committee, opinion of the commission. ঠিক আছে? The writ petition stands disposed of.
My lord, that should be petition number 4, who is 3 marks short.
আচ্ছা 4
5 has already been called.
qualified. 1, 2 and 4.
But this কি করে হতো? But just one
অমনি পাস করে যাবে।
but one request,
Yes, sir.
kindly, if your lordships grant us liberty to appoint any other expert committee apart from not
It
other.
is your committee, it is your expert, it is your body. The court
No,
has not restricted.
Court expert is not my body type. Not kindly appreciate is we don't have any professor. We do not go give any birth to professor or anything. SSC
I
is
do
a
not know. It
no,
is
no.
your
This
choice.
is from the recognized university. We take it.
Yes, recognized university is giving wrong answer. Somebody is saying no, different opinions. What can be
Therefore,
done?
okay.
Neither you nor this court is an expert.
No, I am not expert.
So we
I
do
am-
not know what
I
is the
do-
correct answer.
I do not know.
The commission may take into consideration the books, my lord, that we
Yes.
have, and that
The commission will take into consideration the study materials relied upon by the petitioners annexed to the writ petition. Yes, 5.
my lord, 5, my lord, I am for the petitioner here, my lord. The subject is Sanskrit.
There are 15 petitioners here.
My lord, I have paid the court fees.
Lord, Mr. Bandopadhyay is saying something.
My lord, 15 people, different cases cannot come together, my lord.
What is the matter?
My lord, 15 petitioners are challenging the same questions in respect of subject Sanskrit.
Same question, same.
Question.
All Sanskrit. Which question?
Yes. There are different questions, my lord. Mainly 3 questions are there, my lord.
They cannot be clubbed together.
Question.
Same now.
My lord, question number 6, question number 48, and question number 51.
All three have got all 15 same group.
Same question.
No.
All 15 are challenging the same question. They have different question booklet series, but
Question is the same.
question is the same.
And the preliminary answer was proper.
Preliminary answer, we have raised objection on the basis of the preliminary answer. And my lord, in the final answer key, it has not been changed.
Right.
We have annexed, my lord, recognized books of having ISBN number, that whatever we are saying is correct. What, my lord, we are praying, my lord, let the commission, other than who have considered any other expert, and come back with a report, my lord. Because, my lord, when there are, I have not annexed one, but several, my lord, recognized books showing that our contention is correct.
Only 15 petitioners.
Out of 15, only 1, 2, 3, 4, 5, 6, 7 7 persons have objected.
Have
And-
objected, others have not.
No. Apart from that, Mr. Dasgupta, kindly allow us to speak at least. You people are not allowing anybody. This 7 of them. Now 114. Kindly come to page 114.
Yes.
Someone raised 114 4 objections. 115 2 objections.
114, I see 3 objections, not 4. It is Mamata Maiti?
Yes.
3 objections.
3.
3 actually.
3.
Yes, sorry, Miller. 3. It should be 3. And 115 2 objections.
1.
One objection.
Yes,
One.
1 objection. So, ঠিক করে লিখুন এটা তাহলে। 116 দেখো। 2 objections. 117 3 objections.
How have you considered? Just let the court know.
Miller, this is all the just 1 minute, Miller, huh? Miller, this is the Miller, this is total 975, no? Miller, in one question 975 raised objection. In another question 303 persons raised objections. Now, Miller, this has been dealt with. We have sent it to the expert. Now, expert has said the answers are question number 47's answer are unchanged with original master key. This is expert's opinion. That's whatever it was earlier there. 24 to 47. All questions are there. And wherever the change, my lord, that they have not raised objection there. The objections which were raised by them, expert court says that these are unchanged with
Tell
original.
me one thing, you all recognize the books which the petitioners have annexed. And in
We
other
have-
matters also, I see they have annexed
We have
books.
we have not recognized any books.
That means these books are recognized.
There are so many books in several places, several persons are there.
Why don't you all publish something that these are the books that the commission recognizes so that
No,
everybody gets to know?
commission is not the person to do it. If the education department will do it or the college will do it, we are only meant to conduct the examination, not any other things.
Right. Now they
SSC
are.
has nothing to do. SSC, Malad, kindly appreciate one thing. SSC, just I tell you, SSC doesn't have their own professor. They appoint professor, assistant professor, whatever they are doing from the recognized universities. Only to this extent. Thereafter, whatever comes from the different university, different professors, these are set, paper setting. Then they give a also preliminary answer key. That we publish. Even now, if anybody raises any objection, we don't deal with that. We send it to the expert committee. The expert committee will decide it. But I am not the person who will decide paper. I am not the person who will decide the correct answer. I will not decide whether it's wrong or right. Rather, I am just carrying on the work. I am a bridge between everyone.
Now, the petitioners or anybody who's coming here, they are annexing copies of the study material from recognized bodies.
There may be in one, Lordship knows, in one point, there may be several opinions.
That be so, then all answers have to be correct, treated as correct.
No. The person who is writing the book, what is his authority to write the book? That is also seen. If I today I have write a book for geography.
No, then that book has to be recognized.
No,
Not
if
by
I get
anybody.
it, recognition is not a factor. If it is recognized, finish. Today I am writing a book on tort. I am a lawyer on tort. Now it is recognized.
No, it is not recognized, sir. You get your book recognized.
Kindly appreciate this. If it is recognized, I am saying if it is recognized. If the judges come to a point, no, this is the point of law is not correct.
Then it has to go to an appeal forum.
Even if your lordships does not rely upon any books, where the certain explanations are there. Therefore, one has to go by the expert opinion. There for few persons there cannot be a truncated route. This route is followed for everyone.
The other book which the parties or the litigants are relying is also relied by everybody. How will a candidate know?
We do not know everybody. We know
How
only
will a candidate know which book to follow and what not to follow?
That is not my business to see. We do not know how many persons are following this book. Candidate may have purchased this book. He is following. There are so many candidates.
Yes.
And
So many candidates, so many books.
So many books. If 1,000 candidates are there, 500 books are maybe there.
Right.
The 500 books I will consider.
You say this book to read. Let the state government say this book to read.
No, this is not there. This is not the there. If the state government, does, that's a different part. If the state government does, it is a different part. But how I can be blamed for that?
How do you blame the students or the candidates for that?
No, I am on the opinion. I am going on the basis of the opinion of the professors.
You engage another professor, you get another answer.
But I do not know.
Yes, that is the reason you in the last matter sought for direction to engage some other expert.
No, at that time, still that is in between court and myself.
Yes, yes.
That is not that I wanted to try. I wanted to try to resolve a problem. That's the
Right.
reason.
Right.
That's the reason.
We are
Otherwise, I
trying to
want to
resolve
cooperate with.
problems.
I wanted to cooperate with the court. For that reason, I
Yes,
should not be
yes.
punished by the court.
No, not question of punishment. We are all here for finding out resolutions,
Therefore,
nothing else.
if anything is there, lordships can pass the similar order. Let it goes to the commission to decide. But the point is here. But here, this factually it is different. Not that like that case. It is that the preliminary which is there that has been opined by the expert committee same. Factually, it is totally different case altogether. Earlier case,
No, I understand. I understand. But then I was just
preliminary reply was correct. Expert committee has changed. And here is the case. Preliminary, what is the preliminary that has been kept by the expert?
I can understand this, but then how come these
Now, that is the
study
reason.
materials are coming? I do not know.
Maybe that is the reason where earlier on that day I have cited the judgment.
11 and
But
12.
can I show the judgment, Miller? Other materials will not be taken into
Is the
consideration
state
by the
government
court.
recognizing these books?
Yes, my lord, these books are being taught. Let them say that they do not recognize, they do not know this.
State government recognizes.
Madam, there is a syllabus committee under the West Bengal Board of Secondary Education. Expert body, books will be approved by the government, their number will be there.
See whether this is, please see whether this book is
94.
Oh, yes.
94.
ISBN number is there.
Yeah, please check up.
Page 94.
Yeah, just 95.
Let the state come up with an answer.
Muller, can I say one thing, Muller?
Yes,
Muller,
yes.
on the other day, Muller, I cited one the Supreme Court judgment. If your lordships, I can give it to you again. That
No,
your
no,
lordships
you
has
just
dealt
wait.
with that. And
Just
the
wait.
court, Muller, can I read? Can I read, Muller?
No, I just want to know whether the state is recognizing this book or not.
Okay. I have nothing to say, Muller, on this.
Page 97 or what?
Please come. The petitioners
Right.
participated in the
Yes.
second
পড়তে পারছি আমি।
SHP for recruitment as assistant teachers. On publication of the preliminary model answer key,
কই?
the petitioners raised objection in respect of a couple of questions.
এখানে নেই।
The objections were considered by the commission and the final answer key has been published. There is no change in the answer of the preliminary question with the final answer key.
Right.
According to the petitioners, they have answered the questions relying on the study material from the book, which is book which has a which has an ISBN number. It has been submitted that the said book is taught in classes 11 and 12. 11 and 12.
এটা কোনটা?
ঠিক আছে? 11 and 12
এইটাই তো।
in schools sponsored by the state. Now, in the government sponsored / aided schools. Stop paragraph. Have any of you passed the cutoff?
No, my lord.
None. All right. As none of the petitioners have obtained
My lord,
the
I stand to be corrected. My lord, petition number 3, 4, 9, 11, 14 has been called for verification.
all right, who have been called, who have not called, I'm not passing any interim
Yes, ma'am.
order. Line take it in. Likhun. The learned government representing the state respondent is directed to revert with instruction as to whether the books, ISBN number of which is annexed to the writ petition are recognized by the education department of the state, and whether these books are taught in the schools of the government.
My lord, kindly record my one objection that
Yes.
8 persons have not raised any objection, preliminary
All right.
objection.
Learned counsel representing the commission submits that out of the 15 petitioners, 8 of them did not raise any objection. Right? Release the matter for further consideration on 22nd of December.
But I don't know. Please, short period.
Short period. It is your books. Just tell whether these are recognized. What is the short period? The verification process is going on. 31st is the date. Acha, the receipt showing deficit, payment of deficit court fees, and the service be taken on record.
Case number 7.
Matter, my lord, petitioner applied in second SLST recruitment process for assistant teacher in 2025 in class.
Please take the microphone. Somebody is there online.
Petitioner applied, my lord, in this second SLST recruitment process for assistant teacher in 2025 in class 9, 10 and 11, 12, my lord.
Why are 13 petitioners coming together in one writ petition?
Past experience, my lord. They are applying, kindly see, my lord, page number 172. Similar order has passed by your lordship, my lord. Bring effect. Prescribed staying must to the candidates have been prior teaching experience in aided/sponsored schools under the West Bengal government, my lord.
70-11 order.
They are already working in a school outside the state. But
Outside the state.
my lord,
In which place?
Uttar Pradesh,
Which school? Government sponsored,
government person, my lord.
government sponsored school. Why have you come so late?
My lord, there is a confusion.
What confusion?
Confusion is that, my lord. Kindly see, my lord, page number 165. In the rules, and it is also mentioned that at the secondary level in a government and government aided school of government sponsored school, calculate on the basis of 2 marks for each year in service in a subsequent post. And there is application. But in kindly see in page number 113. When my petitioners applying for their previous qualification, there is only two options for the age relaxation, and the second option, are you working as assistant teacher in any aided sponsored school under West Bengal government? But in the rules, there is no mention about the specific West Bengal government school. There is only mentioned any kind of government sponsored school, my lord.
Where is that? You are working in government schools?
My lord. For
Page? Which page did you show?
page number 35, my lord. Kindly see. Petition number 1, my lord. Anup Roy, petition number 1. School is Harishchandra Intermediate College, Varanasi, my lord.
No. The application form, where is it mentioned that whether you are in any state government school or not? Where? Which page did you rely?
My lord, 165, my lord.
No, 165 is all right, but in the application form,
113, my lord.
113.
113. The application details in, my lord.
Yes.
For the option is, are you working as assistant teacher in any aided or sponsored school under West Bengal?
Yes. So, but then
I am not working in any kind of government aided school in West Bengal, my lord.
right. So you filled in this application form in the month of June.
My lord.
Why are you coming so late?
My lord, there is a confusion, my lord, by the petitioner, my lord, whether they fill the option or not, my lord.
Yes, so let the confusion remain and let the results be published.
But my lord, in the rules, my lord, it is not the mention that it is specific that government aided school under West Bengal have to apply, my lord. It is only mentioned that the any government aided school have to apply for this post, my lord.
All right. Please come.
Page number 172. By the similar matter, my lord, the 10 marks candidate have a prior teacher, and
The
173, my lord.
Where is the court fees?
Paid, my lord. And affidavit service also.
আচ্ছা ওটা রেখে দেবেন. And the petitioners claim to be teachers of
kept on.
government schools outside the state of West Bengal. Stop. They participated in the recruitment process. For appointment of assistant teachers in second SLST, 2025. They allege that they could not fill up the details of their prior teaching experience as no option was provided in the application form for mentioning the details of teachers who do not teach in aided/sponsored schools under the West Bengal government. As the petitioners have prior teaching experience of teaching outside the state, accordingly, they were unable to fill up the said column. Stop. It has been submitted that the rules pursuant to which the recruitment process is being conducted does not restrict awarding marks on account of prior teaching experience only to the teachers within the state. Stop. The rules clearly mention about prior teaching experience in a government or government aided or government sponsored schools in a substantive post as permanent or on contractual basis. Stop. Paragraph. It is an admitted fact that the result of the written test has already been declared and the interview list has also been published. Stop. The petitioner has approached this court only on 2nd of December 2025. That is long after the aforesaid steps have been taken by the commission.
My lord, not in 11-12, my lord. 11-12 results are not came out, my lord. Till.
The result of 11-12 has written
only 9 and 10.
Written test result has not come?
No, both 9, 10, 11, 12 all have come.
All. And the interview list has also been published?
Yes.
As per the instruction, my lord, verification is not completed.
9, 10 interview list has not yet come. 11, 12 interview list has come. Verification has been done. Now the interview has started.
So your client is not giving you proper instruction?
And I have the instruction that not the verification is process is still going on, my lord.
All right.
If the verification is proceeds, then the interview list, unless preliminary interview list is not there, how there can be verification?
Right. Accordingly, the court is not interfering with the prayer of the petitioners at this stage. Stop. The issue as to whether marks can be allotted on account of prior teaching experience is already under consideration before this court in several other writ petitions. Stop. Any order passed therein will govern the others also. Stop. In view of the above, the writ petition fails and is hereby dismissed. These to be written with the records.
Number 8.
My lord, I am for the petitioner. Matter relates to, my lord, higher scale of pay. Petitioner, my lord, appointed as a BCom in a particular school in 2007, and he asked for, my lord, this is the affidavit of service. Page 34 is
Who
the,
is your other side?
my lord, what is happening? Page 34 is the
Other side?
other side, my lord. I have served.
When did you serve?
And the last week, my lord, your lordship upgraded that I have served the notice to the DI as well as the government leader.
You did.
Matter was pending before, my lord, adjudication of the larger bench.
Where is the service upon you have posted to the learned government leader?
Government leaders refused to take because 2023 matters.
What do you mean to say?
They refused to take in hand. Since the time is over, they are not in a position to receive in hand.
Survey copy.
As your lordship.
Let a copy of the writ petition be served in the office of the learned government pleader. তার আগে একটা লাইন লিখুন। The petitioner seeks higher scale of pay. Stop. The presence of the state respondent is extremely essential for effective adjudication of the instant writ petition. Stop. It has been submitted that the office of the government pleader has not accepted the copy of the writ petition.
Since it is 2023.
As the matter relates to the year 2023. Right? এবারে হবে ওইটা serve released on 5th January 2026.
My lord, before, my lord, kindly. Next Thursday, my lord, I will. First time. This is
Yes,
first time.
yes. Let it come. Why are you so much of hurry? Pending from 23 and now all on a sudden
I know, my lord, is going
the
to be retired very
emergency
soon.
cropped up.
Retired very
No,
soon.
for 2 years you didn't take steps. Next.
I'm there.
Item number 9.
Nine. Item 9. Item 9.
Yes, but I'm for the commission. That I am for the petitioner in this matter. বাকিগুলো reason হতে হচ্ছে কি আছে দেখ। My lord, this is a matter for extension of validity of the recommendation in respect of upper primary selection process. My lord, petitioner is a job loser in respect of first SLST. My lord, parallelly petitioner participated in the first SLST in respect of upper primary selection process. But upper primary selection process, a panel of 14,052 candidates has been published by an order passed by the Honorable Division Bench presided over by Justice Chakraborty in the month of, my lord, August 2024. And first
1 minute. Let me hear the commission stand.
Yes.
What is your stand?
Reason order is I'm praying for setting aside the reason order. This is the second time, but I have made a prayer for extension of validity of recommendation, and I may join that particular school. But they have, my lord, first round of litigation honorable court directed to consider, since, my lord, they have the power to, my lord, validated the recommendation up to 150 days. That period, my lord, I made a representation. They have negated my claim that the job losing is not an important factor. So, my lord, they are turned down, my lord. So, I am praying that setting aside that order, my lord. On the other hand, my lord, division bench recently held, my lord, that job losing is an important in a batch of matter who have even not participated in counseling.
Show me that order.
Yes, they have devarying. There is specific bar for further counseling. That honorable division bench held. No, you conducted further counseling in respect of upper price, this selection process. This matter, this petitioner appointed and recommended.
Orpita Pramanik is being relied. Orpita Pramanik is being relied.
Yes.
My lord, unless my friend shows me, it is very difficult for me to catch up with what he is saying. Firstly, he is saying that in the recent order we have said that job losing is not an important factor. But job losing has not been dealt with.
Yes, yes.
It has only been mentioned that he was a candidate of 2016. The petitioner therefore informed about his inability to join after 103 days, that is after expiry of 90 days. Cited above mentioned reason as a ground for inability to join, that loss of job. I presume that is the
Where
loss
are
of
you
job.
reading from?
I'm reading page 26, the reasoned order, which is under challenge.
Right.
The middle paragraph I'm reading, the big
Yes.
paragraph.
Yes.
His ground for seeking extension
Was
he was already working as an assistant teacher of history for classes 9-10 in connection with first SLST 2016, and hence was a
and there was a legal
process in Supreme Court. The petitioner therefore, number one, informed about his inability to join after 103 days. That is after expiry of 90 days. Two, cited above reason as a ground for such inability to join. His prayer was rejected because in sub-rule 3 of Rule 17, the West Bengal School Service Commission selection for appointment to the post of teachers, etc., whereby the commission may extend the validity of the recommendation beyond the period of 90 days for any reasonable cause, for which the reasons to be recorded in writing, extending the period of validity of such recommendation letter for further period not exceeding 60 days. Moreover, total 150 days from that date of recommendation is exceeded. In view of the fact that the ground of his prayer cannot be considered as reasonable cause, simply because the entire selection process got set aside. Thousands of candidates became job losers. They can all of them cannot come back into this selection process. Supreme Court also did not give any such observation that those who have participated in a selection process but have not yet been selected can come back and rejoin. Supreme Court has given lots of relief to the job losers, but this type of relief was not given. If you were working previously, you can go back to your previous employment. But this kind that you can go back and disturb or rather disrupt an ongoing selection process by coming in midway, that the Supreme Court did not allow. Now you were called for counseling. There was no bar. You could have come. You could have accepted your recommendation letter. You could have sat for 90 days after getting it. You could have asked for 60 days extension within the 90 days, before expiry of 90 days, or even after maybe. But you just sat tight. You were confident when you had actually lost your jobs much earlier, pursuant to the direction of the division bench of our court. It was their jobs were already gone. It was only the appeal which was being heard, and they were enjoying a stay. Hundreds of candidates we have extended, but just simply because I was a job loser, I was sitting tight. This we are opposing. The judgment.
How many vacancies are still there?
My lord, firstly, the panel has expired. We have concluded 8 rounds of counseling. That is more or less the end of the selection process. Now, the court had directed us to recommend 14,052 candidates. So candidates, I think 1,242 candidates got left out, for which we were facing, or we are still facing, contempt, which is fixed on Monday. Court has given a direction, the Honorable Court has given a direction that you talk with the state and you get that 1,242 vacancies from the state government.
Filled up.
Yes. No, I require the vacancies.
Oh,
So
you
state will
still
give me
require
1,242 vacancies. And
14,052 vacancies filled up.
no, we had 5,000 leftover vacancies which were not matching with any of the leftover candidates.
All
So we
right.
had 1,242 leftover candidates, 5,000 vacancies not matching.
Right.
In the contempt proceeding, the Honorable Division Bench told us that very well, you sit with this state government will give you
Matching
the
vacancies.
matching vacancies, and equal number of your 5,000 you will return, so that the total number of vacancies with the state remain unaltered. So that is fixed on Monday. That will be heard on Monday, the contempt
No,
proceeding.
that is all right.
Yes.
But then, assuming the direction that was given earlier shall be this consideration of their participation shall be subject to available of matching vacancies.
Yes.
If with a rider, the prayer of the petitioners, whether can be allowed or not.
My lord, this order was passed with regard to absentee candidates. This is not a case of an absentee candidate. This is the case of a candidate who was recommended.
Refused.
Yes. Not refused.
He refused.
But now he is wanting it. So that refusal is withdrawn.
Right. Initially refused and now.
So if each candidate creates this kind of a chaos, I choose a school, I block it, I cannot show it in the next phase of counseling. Then suddenly I come back and I say I want it.
Right.
Now, not just one candidate, 20 matters are before the court. There are many other matters also, maybe not before the court, but they will come the moment this arises.
Yes.
Possibly. I'm not saying it will happen. So keeping all these things in mind, now court, what has the court said, or the division bench has allowed with regard to the absentee candidates, that okay, very well. The single bench had also given the same orders, that subject to the availability of the vacancy. So at best, what might happen? Out of all the candidates, already in that category, we have over 60 candidates already who are enjoying that order. So those candidates, we will show them whatever vacancies we have left after the entire court has also made it clear after completion of this 1,242. So first we will comply with the order as directed originally in the contempt. Then the court has said that for the absentee candidates, okay, very well, you will call them for counseling subject to the available matching vacancies. So my speculation again here would be that maybe 4 or 5 vacancies at the most they might.
There are no vacancies.
No relief.
Do not get a chance.
Yes.
If vacancy.
Yes, but widening the scope when there are no vacancies, that is also not really justifiable.
I understand, but then keeping in mind the situation that has cropped up since the petitioner has participated in a selection test and qualified, you've recommended, he was engaged somewhere else, now job loser, trying to come back.
Moreover, I have seen higher marks.
Moreover,
merit. But
now no merit. You've chosen to give up your merit. Had you been so meritorious, you could have come over here. That you chose not to. Only keeping these things in mind if something can be done, provided there are vacancies available.
The vacancy, the correct vacancy position, here and now, I cannot give it.
I understand.
Because what will be the outcome of the 1,242? Upon that, it will depend that what I have left and whether they will match. And then may I just pray for one thing, because there are 20 matters. Each matter, the statistics are different. All of them have not come up against reasoned orders, possibly.
Yes, yes,
All of them.
Or what except
Oh. Yes, so I checked the second matter.
except by the 10 is the first time, or all other
Yes,
reason.
yes. So I checked the first two matters. The second matter did not have a reasoned order. Then how long after they came? These things are to be taken into consideration.
No,
Let me-
why will the delay in approaching the court be looked into in
No,
that
I'm not
case?
looking at the delay in approaching the court. I'm looking at the delay in approaching the authority for extension. Because we have followed a particular pattern while rejecting or allowing. Those who have given their orders, given proper reasons, my learned friend is also well aware of it, that those candidates we have allowed, even after 90 days, one case my learned friend often cites, she was carrying twins, the candidate, and they had to be surgically aborted. So her condition was very critical, and still within 3 days of expiry of 90 days, she wrote to the commission during the period of her bed rest. So these candidates we are allowing.
Candidates you all are allowing.
Yes.
It's all right. But then see if anything can be done with these candidates also.
Let me cross check the various orders which have also been passed, and let
Because
me come back.
last agenda at your instance only.
Yes, this
20
matter I have discussed, but the remaining matters, there are 20 matters today before the court. Let me come back on a subsequent date. Give a short date. I don't require a long time. Subject to the convenience on the court, it can be on Monday, Tuesday, any day.
Where will Tuesday in that case? Please come.
একটা রিজন অর্ডার করি না ডিসিশন
The
তো ডিসিশন হয়
the petitioner prays for a direction upon the commission to extend the period of validity of the recommendation letter. দেখে নেবেন কোনটা হিজ আর কোনটা হার হবে। In his favor, recommending him to a different school in respect of a different selection process. Stuff. Initially, the petitioner was not inclined to accept such recommendation. But after he lost the job, the petitioner intends to fall back upon the said recommendation letter. Paragraph. Learned advocate representing the commission submits that at present, matching vacancies may not be available where the petitioner can be recommended. Step. The petitioner did not seek extension of the recommendation letter within the stipulated time period. The commission has rejected the prayer for extending the recommendation. Step. Next. Upon hearing the parties, it appears that the petitioner took a very calculated stand and did not act in accordance with the recommendation letter. Full stop হবে না, and permitted the same to expire. Stop. At this stage, keeping in mind the jobless condition of the petitioner comma, the commission may take a sympathetic stand and consider extension of the recommendation letter provided matching vacancies are available. Stop. To allow the learned advocate representing the commission to revert with instruction, release the matter for further consideration on 9th December 2025.
Deeply obliged.
My lord, next matter is slightly different. Yes, next matter, my lord, it is the first time appearing. Commission has not taken any decision. Even my lord, petitioner.
When did it expire?
Yes, my lord, before expiry of the recommendation, petitioner made a representation before.
Show me that.
Yes, yes. My lord, kindly see the recommendation letter, page 18. It is issued, recommendation memo issued on 20th November 2024. My lord, got it? And my lord, immediately thereafter, my lord, on 26th December 2024, petitioner made a prayer within, before the, my lord, cancellation of the job, petitioner made a prayer that my recommend within 90 days stipulated period, my lord, petitioner made a prayer, my recommendation could be extended that I may join the school. That, my lord, in this juncture, my lord, previous honorable bench, my lord, passed several order and passed the mandatory order one, my lord, one I am showing, my lord, one Najma Molli. No, Najma Molli. My lord, since they have approached before 90 days, their candidature could be considered. This is a direction.
See, your letter mentions only about validity, extension of validity for a period of 90 days. That 90 days has expired. How can you seek extension now?
At this stage?
Yes.
My lord, but I made a prayer within 90 days.
So
Then
what?
Considered.
So what? It has to be taken that assuming it was considered and allowed, you could have got at best 90 days. Now that period is also over.
But my lord, ratio of the, my lord,
forget ratio.
My lord,
Now
let take a decision. My lord, let observe the same and let it take a decision.
You have approached this court in August. It is not that you came within the 90 days validity period.
No.
Neither did you come within the 150 days validity period.
But my prayer is within 90 days. My lord, observe the same. My lord, since it is the first time, let the authority take a stand. Since it has undecided.
My lord, that I am objecting to, because the rule, it states that if I extend after consideration of the representation, I am to give reasons in writing.
If you extend.
If I extend.
You can always refuse.
If I reject, I am not under any obligation to consider, pass an order of rejection and intimate the petitioners. Only those who get extension, they are to be considered. That is the rule.
They are to be considered.
Only only for them the reasoned order is to be passed, not for those who I reject.
No, then that
Normally
is
the opposite of what
that is a very bad proposition.
But that is
because
the
the
rule.
moment
That is the rule.
You cannot do that.
That is the
One
rule.
line order is enough. That you applied beyond the period of validity, you can reject it. That line is enough. Why will what is the requirement of passing such a reasoned order?
If I reject in that manner,
right,
then I will have to also give a reason.
Yes.
Reasons are not always restricted
Limitation.
to the date. Reasons are not always restricted to the date.
Then that is something
Reason of
different.
rejection is also, with regard to the reason given by the candidate, is not acceptable.
Yes.
Like here, no reason is given at all, actually, in this.
No, he has mentioned some family issues. Due to my family problem and other related issues. A very vague one.
Yes, vague terms we were not
Yes.
entertained. Unavoidable circumstances.
Last
etc.
week I dismissed
Yes,
the petition.
yes.
Then, so you cannot say
let
that.
this be dismissed also.
But my lord,
Let this be dismissed in line of that judgment.
Dismissed by you. You dismiss it. Why are you relying on the court?
No, I have a precedent, as the court has just reminded me.
Change of my lord after division bench.
No, yesterday division bench also passed two orders with regard to this in a different scenario, but this extension of recommendation in our favor has disallowed.
No, no, it is
there
all
are
right.
multiple judgments crisscrossing.
Yes, yes. Please, some. But I do not find this to be a very good.
Yes, yes. But kindly,
Yes.
my lord, kindly mention I made a prayer within 90 days. That my lord, that I have done. Kindly
What is the requirement of mentioning that? In that case, I will record his submission that you do not have any right for extension.
Then my lord, then my lord, no, no, subject to my lord. But my lord, I am job loser. My lord,
The
kindly mention.
moment you see there is an opposition, you come back.
Yes, yes. My lord, kindly mention I am a job loser. That much.
No, that is not stated in the representation.
He was not a job loser at that point of time. He took a calculated risk.
No, in a true sense, he was, because the division bench had already.
Yes. That way, 1 year back.
So,
in
always
April,
hoping for the best is not the right thing. You got to be ready for the worst.
a bird in hand is worth two in a bush. The petitioner was the petitioner prays for extension of the recommendation letter issued in his favor on 20th November 2024. Stop.
সবই তো reason letter আছে। 9 এর অর্ডারটা তো রিপিট হবে 11
The petitioner was to inform the commission within 6 weeks about joining / refusal of the about his joining or refusal. Stuff. By a communication dated 26th December 2024, the petitioner extension of the validity period of the recommendation letter for a period of 90 days. As he was unable to join within the time period mentioned in the recommendation letter for some family problem and other related issues. Stop. There was no response from the commission. Stop. The petitioner, in the meantime, when the recommendation letter was issued, the petitioner was already serving in a school. Stop. He lost his job in view of the order passed by the Honorable Supreme Court on 8th March 2025. Date একটু চেক করবেন তো?
3rd April possibly.
3rd April 2025. Stop. The petitioner has filed the instant writ petition on 26th August 2025, praying for a direction upon the commission for extending the validity period of the recommendation letter so that he can join in service. Stop. Admittedly, in the instant case, the recommendation letter expired long back. Stop. The petitioner did not approach the court within the validity period of the said letter, seeking extension of time. Stop. After he lost the job, the instant more than 4 months after losing the job, the petitioner has approached this court for relief. Paragraph. The prayer of the petitioner is opposed by the learned advocate representing the commission. Stop. It has been submitted that the commission is not obliged to give any reason for not extending the validity period of the recommendation letter. Stop. The recommendation letter expired long back, and at such delayed point of time, there is hardly any scope to reconsider the same. Paragraph.
September.
Upon hearing the submission made on behalf of parties and keeping in mind the fact that the petitioner has lost his job and it may be difficult for him to lead a normal life without employment. Accordingly, the court directs the commission to take a sympathetic view of the matter and consider the prayer of the petitioner for extending the validity period of the recommendation letter, subject, however, to availability of matching vacancies. Stop. The writ petition stands disposed of.
Yes. My lord, in respect of item number 9, my lord, only
1 minute.
yes, item number 10, my lord, one line be added. If the vacancy is available, let the commission indicate the vacancy in
So
respect.
here and now we cannot identify them.
No, this not
এটা
10.
10 হলো।
Respect
এটা
of
লাগবে না,
item
এটা
number
ফেরত দিয়ে দিন।
No, 9 also. We cannot identify vacancies
My
until.
lord, if the vacancy is available, kindly indicate that only that part.
No, it has been mentioned. They will consider your case only if
The tenant.
there are matching vacancies available.
Item number 9, respect of item number 9.
No, this is 10.
10, no. Item number 9, your lordship asked for a report and come back with director my lordship to come back. Only one line be added. Kindly submit that whether the vacancy is available.
That
Where
I
have
cannot
been
say at this stage because
Because
until
it-
let
the
him come.
vacancies are finalized. I cannot.
All cannot be done. Monday there is a contempt. Monday they have to file a report before the court taking up the contempt matter. This matter is fixed on Tuesday. Immediately thereafter, whatever he gets, let him come. Thereafter, the court will see.
Yes.
Deeply obliged.
Item number 11.
Same order as 9.
My lord will kindly excuse me. Junior is here.
Same order as 9. Give your service.
And for the commission at all service.
One by one. One by one.
One by one. My lord, item number 9, item number
9.
10. 10, yes, it is 11.
11. 12 respondent.
12.
I for the commission, my lord.
Yes.
Yes.
Same order as 9. 13.
Yes.
I'm for the commission.
14.
Yes.
49 for the.
I'm for the commission.
Same, all same. Baki gulo sab same.
40. That's right.
15.
I'm for the commission.
এই যে service.
16.
16.
Yes, my lord. Service.
17.
Yes, my lord. Service.
18.
Yes, my lord.
19.
Yes.
20.
Yes.
21. 22.
Yes, sir. So check up with
23.
my lord.
24.
Yes.
My lord, I'm for the state, my lord. 24.
25.
Yes.
My lord,
26. 27,
For the state response.
28,
I am for the state.
29,
Great.
Great, my lord.
Have we got?
In this matter, my lord, already, my lord, 20 November 2025, my lord, pass an order. The petitioner having a autistic baby, my lord, who wants to transfer from Kolkata to Malda, my lord. And this is a school, my lord, rear of the rarest minority school, my lord, rear of the rarest occasion, my lord. This type of vacancy arose, my lord. And the report which I got, my lord, from it is evident that yes, there is a vacancy. But in past category, I even, my lord, I asked my client also, because I want, my lord, client will give that my lord, instruction, my lord, directly, because I don't want it in my shoulder, my lord. If my lord's permit, because no client is permitted. If my lord's permit, client just outside of the court.
No, 1 minute.
My lord,
Yes. What
the-
does your report say?
my lord, report says that, my lord, the vacancy is in past category. My lord, I have already on the earlier occasion handed over. My lord, the second thing is that my lord has asked the difference of pay, which I have given at paragraph number 2. The pay scale difference is, my lord, this is, my lord, for the initial stage we have indicated, my lord, at as per now, my lord, as per the my lord, she is going to retire 6 or 7 years left, as I have been intimated. That she is now getting at almost 1,13,000. That will come down to 48,000. That is my lord,
So much of
so
difference?
much of difference.
And my lord, that's why my
1 lakh 13.
13,000 as
And it will come down to 48.
48,000. As my lord, he has written down that. I have not given, because my lord's direction was only to give this thing.
I believe, my
And
lord,
third thing, my lord, it is, my lord, contrary to the rules, because the rules, my lord, by which these transfers are made, my lord, they should be of the same body.
There is 76.
Suppose, my lord, the bodies are different. Where this, my lord, the petitioner is working in Calcutta, and the body of that in Malda, they are different. My lord, I have indicated that.
In that case, can the state find out a suitable vacancy where the petitioner can be accommodated?
Lordship, I have received one.
What does the report say? Give a copy to the petitioner also, so that he also gets to see.
At paragraph 3, Lordship, you can
Hmm.
see. It is special rules.
Special rules, এটা আমি নিয়ে এসেছি, rules.
Under body আলাদা।
হ্যাঁ, from the body.
এটা হতে পারে।
See, it is the
the mere technique.
Archbishop of Calcutta and the Archbishop of Malda. This is the difference.
Nothing. The technical.
Will this be such a factor that the petitioner cannot be accommodated?
My lord, the rules, my lord, kindly sees.
Rule 12.
Rule 12. My lord, may I hand over?
Yes. So
Okay,
it is
my lord,
mentioned over here. It is mentioned, sub rule 1 of 12.
in this case, my lord,
Any sanctioned post may be filled up by way of transfer, holding the same region and run by the same governing body, founder body. Hmm. Where are the, suppose, assuming that the petitioner cannot be transferred to this school, do you have any other matching suitable vacancy where the petitioner can be transferred?
That I have to take instruction.
Because the petitioner is in trouble, she has an autistic child, and a sympathetic view has to be taken.
Yes. My lord, everything has been.
even she says, whatever the salary.
See, 1,13,000 coming down to 48, less than even half the lady is willing to accept.
But probably there will be difficulty in.
But I could say, my lord, in disability.
Bodies are different.
How much will it be difficult?
My lord, my lord, though I am not appearing for the my lord,
State.
district and state
Yes.
matter, my lord, the difficulty I have thought from other my lord DI that there will be a difficulty in accommodating the preparing of the service books and everything because my lord, she is my lord serving in a particular post. My lord, she was appointed in that particular post. She is my lord all the scale of pay and everything has been adjusted in that fashion.
Now you have to readjust. She is voluntarily giving up. She is surrendering her right.
Voluntarily wants to. And
My lord,
my client is present, directly take instruction.
Find out a way as to how she can be accommodated over here. Whatever is required to be done, please do it.
মালদা ডিস্ট্রিক্ট ডিআই কেও পার্টি অ্যাড করে দিতে হবে
Okay.
let them add.
My lord, whether this school where my lord Leonard's client is my lord working, whether that school has another my lord
No, she
set of
wants to go there.
no that maybe there is a school in Malda also run by the same governing body, my lord, that can be found out.
No, there is no.
Had there been so, she would have gone there.
That is the difficulty, my lord.
And these minority institutions, the name appears to be same,
Yes.
but then they are not from the same body.
No. Actually, my lord, there is a fraction. Nothing is actually the body is the same. There is a fraction. The lawyer.
But now this fraction is creating problem. Find out an alternative as to how this
my
lady can be
May
accommodated.
I indicate one thing, my lord? Because of that, my lord, it is postulated from the Disability Act, my lord. I want to, my lord, canvass one section of the Disability Act, that is central legislature. And in the line of that central legislation, the central government passed such notification, my lord. I just read, my lord, one
Yes,
section.
Chief.
Section 31 of the, pardon me, because
Yes.
it is in my, just I read it. Section 31, free education for children with benchmark disability. Notwithstanding anything contained in the Right of Children to Free and Compulsory Education Act 2009, every child with benchmark disability between the age of 6 to 18 years, because of that, my lord, in Right to Education Act, there is 6 to 14. But in this type of special child, their right 6 to 18 years shall have the right to free education in neighborhood school or in a special school of his choice. So there is two types of school. That is this child for the this all for the beneficial of this child. And in this line, my lord, the central government passed several notifications to accommodate the parental transfer, my lord. And in this regard, my lord, the central government notification is also there. But the
No, but then this is not central government. The
Yes,
lady.
yes,
but my thing is that, my lord,
the state government, my lord.
No, doesn't matter. 1 minute. The lady stays in Malda.
no, my lady stays in Kolkata, but the father and the family stays in Malda. And the child is such a value because of that, this type of, she can't, my lord, by single-handedly can't.
So the lady has to go back to Malda. If somewhere the lady can be accommodated.
That's the problem.
DI Malda is a party in the writ petition. Yes, leave was granted and Malda has been added. All right. You take a note DI Malda is the respondent number 8. The school and the headmaster are respondent numbers 9 and 10. Right? So you take instruction from DI Malda
9 and 10.
without any delay as to how this teacher can be accommodated, where she is to be accommodated, and whatever is required to be done. Followed?
Kindly,
I'll mention it in the order sheet. Please come.
may I hand up the government notification regarding?
You keep it with you. I do not want the notification.
It is 9 and 10.
Learned advocate representing Rohutara St. Thomas High School within bracket HS. Produces a write-up, a report from the headmaster of the school signed on 1st December 2025, mentioning the difference between the scale of pay of a past graduate teacher and a postgraduate teacher. Stop. The petitioner, who is currently enjoying the postgraduate scale of pay, is agreeable to accept the graduate scale, the pass scale of pay, as she is urgently required to relocate to Malda for taking care of her child who has special needs. Stop. The report of the headmaster also submits that the founder body of the Rohutara school is different from the founder body of the Kolkata school, where the petitioner is currently teaching. Stop paragraph. As the the district inspector of schools is directed to consider the instant case as a special one, keeping in mind the special need of a minor female child.
Male child.
And
male child.
আচ্ছা মেল চাইল্ড তাহলে মাইনর চাইল্ড করে দিন মাইনর চাইল্ড and locate an appropriate vacancy where the petitioner may be appointed. Stop. Release the matter on 10th December.
Only child.
The report by the District Inspector of Schools, Secondary Education, Malda, signed on 28th of November 2025, be retained with the records. You can ask your client to join. The District Inspector of Schools, Malda, Secondary Education, Malda, is directed to remain virtually present on 10th December, when the matter will be taken up for consideration by the court.
the interim order will continue, my lord. We have
Yes,
Order dated.
the interim order. Directing the Rohutara school not to finalize the recruitment process till the disposal of the writ petition shall remain in force. It is still disposal, so it is
Yes.
already there. I
So,
again made it clear.
Chakraborty is appearing in this matter, my lord.
No, I'm for the
He's
commission.
suffering from conjunctivitis, my lord. I've been instructed to, my lord, seek accommodation for a week.
All right. Accommodation has been sought for on behalf of the learned advocate representing the petitioners on such prayer released on 5th January 2026.
Great.
Item number 32.
I am for the petitioner, my lord. My lord, this is that matter, my lord, whether the matter is to be heard in the High Court or the SAT, my lord,
Oh,
AG appeared.
right.
Because it will
Next
take
week.
some time. but-
January. Let the matter appear in the list.
but
And-
they will-
Next week.
Next.
Release the matter on 16th of December.
The advocate, learned advocate general is also engaged.
Yes, yes.
Item number 33.
33 minute I appear. কোথায় গেল রে? শান্তনু ছিল তো? Well, I'm for the petitioner. তুমি বলে দাও। মানে it is the case of reassessment of the answer script in a higher secondary candidate in respect of the Google and history. Education. Education. Geography and education. Well, I have checked up the judgment, all are against me. That the evaluation is not permissible. But if the court satisfied, no, there are some illegality, irregularity, then my lord, one of the judgment says that the read court can exercise his power. Out of that judgment, I shall be placing before that. What is the illegality? Why I am coming before this court? If the one number is added, he will be, she will be in the, my lord, the 10th positions. Up to 10th, my lord, these are the merit list, 10th standard. If the one number is added, he will. That is the only reason. Otherwise, for 1 or 2 or 3 numbers, nothing will happen.
It will happen. It matters a lot. Even fractions matter.
Anyhow, I was wondering why are you so?
No.
Because the one, well, he said, and my lord, I was convinced that categorical statement was there that only to deprive her claim that she could not come within the zone of 10th. But this step was taken. And answer script, each and every reply, there was cut. In the cut marks, initial marks was given 6, thereafter it was reduced 5, not only one, each and every answers. If your lordships kindly consider this aspect of the matter. Thereafter I said, place one judgment.
Show the answer script.
Yes, yes. Reasoning was there.
Reasoning?
Yes.
All right. Let him show first. Let him show.
Page 77, your lordships kindly have a look. Question of 77. Okay. Page 77, 3A. This is the question, 3A. Your lordships kindly have a look to this 3A question paper.
3A has got 7 marks. 6
Yes,
plus 1.
6 plus 1. Now, your
Describe
lordships
what
kindly
is
reply.
superimposed drainage. 3 landforms produced by the.
Now, my lord, the reply, page 84. 3A, it has been started. Page 84, top. 3A, 1, 2, 3, 4, 3 per 3, it will be counted 2 into 3, 6 marks. 6 marks. Now,
No,
the,
1 minute. 3A means 84.
yes.
84, 1.
Minimum
2,
3 numbers, 3 answers are required to be taken into considerations. So show 3A, 1, 2,
and 3.
and 3.
Yes.
As of 4 was also there, but the 3 will be taken up. 3 into 2, 6.
All right.
Now your losses kindly see the 4 remark portions.
Remark portions.
86.
হ্যাঁ
চিত্রের
চিত্রের উপস্থাপন ঠিক হয়নি
ঠিক হয়নি।
হ্যাঁ
This is the remark, চিত্রের উপস্থাপন ঠিক হয়নি। Now my lord, the marks initially was given. Initially 4 half plus 5 and first 6. Thereafter 4 and half and 5. And ultimately 5 was given. Thereafter, my lord says kindly see the below portions. আচ্ছা একে এক। কত?
5 marks were added.
5 plus
3C, page 92, 96.
Question number 3.
92. Question number 3C. Question number 3C.
এখানে start হচ্ছে এখানে।
তাইতো? দেখে না।
Page 89.
It starts from page 89. PC তো?
হ্যাঁ হ্যাঁ এটা দুইয়ের question।
89
Page 89 starts 3C. My lord, all are correct. And my lord, and marks calculation was 92.
92
92 page. And page number 92.
Prior to that, your lordship kindly takes page 91.
আমি বলছি তো তুমি চান্স
ওটা দেখাচ্ছ না তো তুমি।
তো তুমি দেখানোর চান্স পাবে না।
92
92.
3 plus 1 plus 1.
Yes, 3 plus 1 plus 1. Initially 4 plus 1. Then my lord 5 and half, 5 and half. Thereafter 3, 1, 1, 2, 5, 6. Ultimately 5.
See, whatever the examiner has given.
No, not only one. I have, that's why I purely submitted. Not only one question. Now your lordships kindly see. Page 78. Page 78 is the question. Page 78 is the question. Below portion C. The state one characteristics of planning region discussed with the problem associated with the overpopulation in different countries in the world.
Answer হচ্ছে 96.
Answer is 96.
How come the questions are in English and the answer are in Bengali?
There are two versions.
Two versions are there. Versions are
So Bengali questions are also,
Also there.
Permissible.
you have annexed the English ones.
Yes.
Yes.
Now 96. E.
Answer.
Petitioner given the answer 96 E.
And these things are not equally example D. Given 7 examples.
6. Mala given the 6 example.
See, given
There's-
6 example, why if 3 has been given and not 4? Can the court look into this?
Page,
Start হচ্ছে
page starts from E1, page 96. E.
given 6 example for 6 marks.
E. You also got it? E.
Yes.
1, 1, 2, 3,
Right.
4, 5, 6,
Yes.
up to 6. The example was given up to 7. Now, your lordships kindly, page 99, the remark of the examiner, উদাহরণ সহ উত্তর দেওয়া হয়নি. There is no such, মানে in the model answer যে উদাহরণ সহ উত্তর, মানে the remark was উদাহরণ সহ উত্তর দেওয়া হয়. তারপর কথা হচ্ছে
96 এই একটা উপর portion.
and page, if your lordships kindly see the 99 page top.
Initially, the marks were given 68.
Initially, the marks was given 68. Now, your lordships kindly say next page, page 100, 66.
No answer was given by the petitioner.
And the no answer was given by the petitioner on that day. Now, your lordships kindly see the caging portions, page 79. Page 79, if your lordships kindly have a look. There are multiple corrections in the caging portions. Initially, it was given 68, then 66. Statement ওইটা কোনটা আছে জিওগ্রাফি একটা না না ওটা তো হলো না যেটা আরেকটা এডুকেশন এটা না এটা
See, possibly the questions are first checked by one teacher and thereafter again checked by another, and that is the reason this has happened. And it happens in each and every students.
Each and every questions, and there is a great doubt whether it was correctly afterwards.
There is no scope. You have to rely upon that authority.
No, because of the fact, my lord, I only real lordships kindly the the other, I started my argument that the all judgments are, my lord, the paragraph 20 paragraph তুমি বলেছো সাইটেশনটা তুমি অলরেডি ভর দিয়েছো আছে নাম বলতে কি আছে অসুবিধা কি 2019 16 এসসিসি your lordships kindly have a look to this para 20 and 21 2019 ভলিউম 16 এসসিসি আছে অলরেডি দেখিয়েছো অলরেডি জাজমেন্টটা অনিরুদ্ধের ঘর যেটা দেখিয়েছিল অলরেডি জাজমেন্টটা বার করো education data all page 2019 হ্যাঁ 16 model answer. Babu and Anna. I could good question for
Yes.
Now, your lordships, I'll finish page 30, the education subject, page 30, if your lordships kindly, page 30. Define central tendency, find out the mode from the following frequency distribution. This is the page 30, the question. Number the answer is page 40, 40. Answer is page 40, your lordships got it. Answer is correct, but the examiner's observation short method. Initially it was given 6. Thereafter প্রতিটি স্টেপ পড়লে পুরো নাম্বার দেওয়া যেত, Now your lordship kindly see the model answer, page 60. Text is C. Give full marks to the proper definition of the central tendency. Give full marks to the correct calculation of the mode. For proper arrangement of the table with class boundary, you may give 1 mark answer mode 5 to 9.5. Now your lordship's answer is correct, but short method. We do not know what is the short method or long method. In a model answer, there is no such indication. Well, I have pointed out these are the only one and categorical statement was made in paragraph 9.
Yes, what is your submission?
Lord, your lordship has seen the Lord answers to the questions papers. The model question paper and answers they are referring to, that is not the benchmark. The way and the parameters in which the examiners are assessing the answer scripts, that creates the benchmark. We don't treat the model answers as a
Who has published this model answer? You?
no.
Oh, it's by some other body?
Chaya proportioning and other things.
Some other body.
And if your lordship kindly sees the answer, each and every answer where some corrections are made, ample reasoning was there. Reasoning was there. And
What is the system? One teacher corrects or there are two? First one and thereafter somebody else rechecks.
Teacher corrects, thereafter goes to the head examiner.
She rechecks. So there is two.
And he applied for in terms of regulation 21 sub-regulation 6, he has applied for post-publication scrutiny.
That was done.
There is no change. No. So our regulation says that is binding. We don't have any rules and in the regulations.
What is your rule to show that after it is corrected by one, it goes to the other? Please show that.
Rule 21.6 says in the next matter, that is item number 34. I have
it is annexed. देखिए पॉरेटा देखिए एक तो पॉरेट फाइल का देखिए. Wait, just wait.
No, your lordship kindly have it.
No, I'll see only the rule. রাখুন এখানটাতে. রুলটা আছে. Yes, which portion of the rule you say?
21, regulation 21 has a lordship got it,
Regulation 21.6. The result of the post-publication scrutiny shall be final and binding. Now show me that two teachers check it.
But that is not written. It is not practice. That is not written in the rules. That is not written. That is not.
Who made the corrections? The same teacher?
No. Different. This is not written in the mention in the rules. 8 plus 10 plus examinees are there. And he alleges malafide and malicious people. What is the cause?
No, that I'm not taking into consideration, but show me that it must be written somewhere.
Kindly see method of assessment.
Yes.
Regulation 20.
Right.
The name.
The method of assessment of answer script shall be numerical. That is to say, the assessment shall be made in terms of the marks to be awarded by the examiner. Examination of practice is another thing. This is the method of examination. The council shall have the grade and classification. It is another thing. We are not related to this.
So I just want to know that why this correction? If I correct one answer script, will I go back and recorrect it?
what played on the mind of the examiner, my lord, he is the expert in this matter, my lord, in that matter, my lord. We can right now we can comment, my lord, but from the reasoning your lordship sees, my lord, time and again he checked, verified. He was not satisfied the marks he has given. That's why
He gives a marks and he is not satisfied.
no,
You
initially-
give a mark, somebody else may not be satisfied.
initially he puts a mark.
But they're not satisfied.
Then after reading the answers, he thought
He gave a mark after reading the answers,
Yes.
not that without reading he gave the mark.
repeatedly he read the answer.
Repeatedly.
Yes. That's why
The examiner has so much of time to give repeated look into the answer
the
scripts.
reasoning is there. Your lordship kindly have a look at it.
I understand. This is what I want to know, whether the reasoning is of the first teacher or the second one.
But I believe it's a first. সঠিক সংজ্ঞা লেখা হয়নি. Kindly see page 92. One side reasoning. সঠিক
But
সংজ্ঞা
if
লেখা হয়.
there is a two teachers, the query of the code, then there will be the difference of the ink. Same
No,
ink
no.
cannot be correct. If the one teacher, same ink. So let there be production.
Why?
of
You cannot have two pens?
Yes, madam.
Then
No.
you can have two pens.
No.
When you read for the first time, you use a blue pen. Next, you read for the second time, you use a black one. And the third, you use a green one. Then what happens?
I do not know.
You have so many pens.
I do not know.
Whether each and every correctness what is there in the
There is some doubt.
I understand,
No,
but
no,
then
reasoning has
with so many scratches and cut throughs.
Reasoning has been given. And Milord, I have relied on two judgments of this honorable court. Milord, in the next matter, I have cited those two judges of our.
Your learned friend's opening submission is all judgments are against him except one that where he can lay his hands
Thereafter,
upon.
the judgments of Supreme Court, Milord, says, Milord, in absence of any provision in the relevant rules and regulation, then, Milord, a candidate cannot ask for re-evaluation, reassessment of his Milord, answer script. And Milord, this is Milord 2023 live law, Supreme Court 131. Milord, Dr. B.R. Ambedkar University, Agra versus
Whoever. Yes.
Lordship, kindly have a look at it, Milord. Lordship,
Let me see.
Milord, head note, Milord. Re-evaluation of answership. Supreme Court disapproves of High Court ordering re-evaluation of answerships when there is no statutory provision. Moreover, the award of marks in descriptive type of answer. This is the descriptive type of answer. Essentially remains a matter of subjective assessment, and the court would not be entering into that arena of assessment which remains reserved for the examiner, regulator, however, having regarded the superior refuses to interfere, relief granted by the High Court.
Refuses to interfere with the relief.
But Milord,
That means
principle has been laid down, Milord.
yes, certainly.
Milord, one These honorable court, after Milord, considering all these judgments, Milord. Milord, after considering all these judgments of the Honorable Supreme Court, Milord, one coordinate bench passed this judgment, Milord, rejecting the claim of the petitioner for reassessment of the answers. All the judgments have been relied upon and all the judgments have been discussed, Milord. All the judgments, each and every judgment, Milord. Right up to Milord, from Milord, Maharashtra State Board, Milord, Maharashtra was the State Board of Secondary Higher Secondary Education to till Milord. It is judgment pronounced by the Honorable Court. That is, Lords, that also been considered. After the judgment, না না টমেটো মনে আছে নিচে কোথায় গেল ইন্টিরিয়ারটা ইন্টিরিয়ারটাই After your lordship is looking at the judgment passed by this audience bench of this honorable court. The latest judgment will Dr. NTR University of Health Sciences. That is a paragraph 30. Ultimate paragraph.
30?
30.
Yes.
In the matter of Dr. NTR University, has your lordship got it, madam?
Yes.
Your Honorable was placed to observe as under the short question which is posted for consideration before this court is whether in the absence of any provision for evaluation, the High Court was justified in ordering evaluation after calling the record for the answer scripts. In view of the above and for the reasons stated above, the common judgment order passed by the Honorable Single Judge ordering re-evaluation of the answer scripts confirmed by the division bench by the implicit common judgment and order is unsustainable. However, as observed herein above, as the result of the order is to after re-evaluation or appearing the supplementary exertion have been declared while washing and setting aside the impugned common judgment or orders passed by the Learned Court, Learned Single Judge as well as division bench of the High Court, the same shall not be affected or disturbed. The impugned common judgment and orders passed by the Learned Single Judge as well as division bench ordering re-evaluation of the answers in absence of any such provision in the relevant rule are hereby quashed and set aside. However, as observed herein before, the same shall not affect the declaration of the result of the original petition on re-evaluation.
Please come.
And Milord, one thing, Milord, I must tell before your lordship, Milord, because there are so many corrections in the answer script, I have personally asked my officer, Milord, to take it because Milord, academic interest of a student is involved.
Yes.
It has been checked, and this is the report. After I got the brief,
All
I
right,
asked my
please.
officer. Since Milord,
The
academic
petitioner appeared in the higher secondary examination conducted in the year 2025 and secured 487 marks. Stop. She is aggrieved with the marks awarded to her in which subject? Education.
education and geography.
Education and geography. Stop. A post-publication scrutiny was sought for, but there has been no change in the marks awarded to the petitioner. Stop. The instant writ petition has been filed, annexing photocopy of the answer script forwarded to the petitioner under the Right to Information Act, 2005. Stop. It has been pointed out that in more or less all the answers of the geography paper have been penned through and lower marks given. Stop. The petitioner submits that had she been given one more mark, she would have qualified as the 10th successful candidate in the examination. Stop. Paragraph. prayer has been made to reassess the marks in respect of certain questions in education and geography. Stuff. The petitioner, in support of the submission that in exceptional cases, comma, the writ court possesses the power to direct re-valuation. Stop. আচ্ছা রিলাইজ अपन ডিসিশন বললাম তো in the matter of High Court of Tripura through the Registrar General versus Tirtho Sharoti Mukherjee and others, reported in 2019 16 SCC 663. Next. The prayer of the petitioner is opposed by the learned advocate representing the West Bengal Council of Higher Secondary Education. Stuff. It has been submitted that there is no rule permitting re-evaluation of the answer script of a candidate. Stuff. There are lakhs of candidates who appear in the higher secondary examination every year, and the allegation of malafide cannot be taken to be proper. Stop. It has also been submitted that despite there being no provision for re-evaluation, comma, the council again verified the answer script of the petitioner and did not find any change therein. Stop. It has been submitted that the answers, the marks of the answers which have been penned through bears a proper reasoning for the same. Stop. Next. The council relies on the judgment delivered by the Honorable Supreme Court in the matter of Dr. B.R. Ambedkar University, Agra versus Devarsh Nath Gupta and others. Reported in 2023 live law within bracket SC 131.
Paragraph 13.
Paragraph 13. And আরেকটা জিনিস লিখুন judgment dated 14th February 2023 in civil appeal number 1141 of 2023, arising out of SLP within bracket C number 27252/2019. Stop. Reliance has also been placed on the judgment passed by this court on 10th March 2023 in WPA 4541 of 19 within bracket Onkur Manna versus State of West Bengal and others. In support of the submission that the court cannot permit re-evaluation of answer scripts in the absence of any statutory provision. Stop. Paragraph. I have heard the submissions made on behalf of both the parties and have perused the documents annexed to the writ petition. Stop. Though it appears that there are several answers which have been penned through and lower marks have been awarded, but admittedly some reason or the other has been mentioned for the same. Stop. it appears that the answer script of the petitioner was scrutinized and there and no change was found. Stop. The courts have all along deprecated the practice of directing the authorities to re-evaluate answer scripts in the absence of statutory provisions. Stop. The court is of the opinion that this is not a fit or a rare case permitting re-evaluation in the absence of statutory provisions. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. Stop. The writ petition fails and is hereby dismissed.
Well, 34
is similar matter.
Which thing? Judgments. It will be recorded and then you can take it back. Let it be recorded.
Yes, yes.
Thereafter, take it back.
The next matter is also same. Evaluation.
It's for the petitioner.
And for the petition.
Oh, yes. What is it?
On the last occasion, Your Lordship, the opposite party had submitted that in the absence of a provision, re-evaluation cannot be permitted. However, Your Lordship, this judgment of the Supreme Court, you kindly need to.
Which one?
This is 2009 Supreme Court three-judge bench. Here it says that even in the absence of a provision, it can be done. I'll just place the relevant fact.
Under what circumstances?
Yes, I'll just place the
2009.
2009. However, Your Lordship, kindly note that this judgment has been recently cited before this court only.
Maybe.
Yes, sir.
Yes, please show.
Yes. Your Lordship, kindly come to para 26, page 8. Para 26. I'll just read it. The division bench of the High Court has set aside the judgment of the learned single judge on the ground that the Vice Chancellor of the university had no power to order re-verification of the answer scripts. The rest is not relevant, Your Lordship. Then kindly come to paragraph 32, the next page. Paragraph 32 says the plea that there is absence of specific provision enabling the Vice Chancellor to order re-evaluation of the answer scripts and therefore the judgment impugned should not be interfered with cannot be accepted. Re-evaluation of the answer scripts in the absence of specific provision is perfectly legal and permissible. In such cases, what the court should consider is whether the decision of the educational authority is arbitrary, unreasonable, malafide, and whether the decision contravenes any statutory or binding rule or ordinance, and in doing so, the court should show due regard to the opinion expressed by the authority. Then, Your Lordship will kindly come to paragraph 36. Paragraph 36 here, the Supreme Court in the Board of Secondary Education case was of the opinion that the question whether in the absence of any provision to that effect, an examinee is entitled to ask for re-evaluation of his answer books was examined by the Supreme Court in so and so. The rest is not relevant, Your Lordship. Then paragraph page 11, the next page. After that, it says the above decision deals with the right of the student or candidate to claim re-examination, re-evaluation of his answer sheet and the power of the High Court to order re-evaluation of answer sheets. It does not deal with the power of the board to order re-evaluation of the answer books if the factual scenario so demands. Now, Your Lordship will kindly, my case is that the petitioner herein is agreed with the marks of the business studies answer script as stated. Applied for the PPS post-publication scrutiny, there was no alteration in the marks. However, if Your Lordship will kindly note, the business studies paper consists of two portions. One is your objective portion and the other is your subjective portion. I am only on the objective portion, which is talking about the MCQ portion. There are 24 MCQs, and if Your Lordship will kindly come to page 52 of my writ petition. Has Your Lordship got?
Yes.
52, if Your Lordship can see the red marks. Originally,
I have got a black and white paper, so red I cannot identify.
Turn over the page.
Yes.
52, 3 plus 1 at the bottom. 3 plus 1 in red.
How do you identify red? You have colored markings.
Yes. After
I am favored with only a black and white.
if you turn over that page, after that,
Probably, my lord, it has been re-examined by a private tutor. That is his
it
remark.
Your Lordship,
Last and
it has been examined by independent examiners who have
Independent examiner means?
Page 36, your lordship looks at.
1 minute.
No.
1 minute, yes.
Independent examiners as in teachers of other colleges. Petitioner got it corrected.
How does it matter?
It matters, Your Lordship, because as far as the MCQ portion is concerned, 4 questions, in these 4 questions, marks have been awarded by both the teachers.
You are appearing in an examination and there is a body who conducts the examination. There are examiners, there are evaluators and everything.
Yes.
You have to depend upon them. You cannot rely upon the inputs from outsiders.
Your Lordship, the fact that 2 other teachers have examined, I'm only talking about the MCQ questions because, Your Lordship, in the MCQ question, the answer can either be correct or it can be incorrect. There is no scope of ambiguity here.
I am getting here everyday matters with more than 1 correct answers. Anybody is marked, whoever attempts, marks to all who have not even attempted. What to do?
Lordship, however, Your Lordship, the student here is a meritorious student. Single mark can determine the course.
Either make it or break it. Cannot help. Please come. The petitioner participated in the higher secondary examination in the year 2025. He claims to be a very meritorious student and he secured very good marks and grades. He secured 457 out of 500 and has an overall percentile of 99.161. Yes. He raises issue with regard to the marks awarded in Bengali and business studies. Stop. He got his answer scripts obtained by him under the Right to Information Act and rechecked and re-evaluated them through teachers who teach in other reputed institutions. Stop. The petitioner submits that the marks awarded by those teachers suggests that the answer given by the petitioner in the MCQ is correct. Stop. The petitioner's answers have been erroneously marked as incorrect. Stop. It has been submitted that 1 mark will make a lot of difference in the ranking of the petitioner. Stop. In support of the submission that the court may permit re-evaluation of answer script, the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Sahiti and others versus Chancellor, Dr. NTR University of Health Sciences and others. Reported in 2009, 1 SCC 599. Yes, sir. Prayer has been made to direct the council to re-evaluate the aforesaid answer scripts. Stuff. Next. The prayer of the petitioner is opposed by the learned advocate representing the council. আগের মামলাটাতে কাউন্সিলের যা submission, all will remain over here. The judgments referred will all remain. ঠিক আছে? On a perusal of the judgment in the matter of Sahiti within bracket Supra, it appears that the court was of the opinion that re-evaluation may be permitted if the factual scenario so demands. Step. Upon hearing the parties and upon perusal of the documents placed before this court, the court is of the view that the instant case is not such that re-evaluation may be directed to be conducted. Stop. Next. In view of the above, the writ petition fails and is hereby dismissed. You can take this copy back because there is another copy over here.
Lordship, just
Extremely
one
grateful, my lord.
Lordship, just one thing. The answer script is only one answer. The re-evaluation is only with respect to
No,
one
no,
answer.
not Bengali.
Not Bengali.
Achha. Re-evaluation of. You never sought for re-evaluation of Bengali.
No, Your Lordship, only business.
ঠিক আছে, তাহলে business studies কে রাখবেন, not Bengali.
My lord, we are appearing for state in this matter.
Give your appearance.
Matter item number 1.
Lord, I'm for the respondent contempt, Lord. Lord, in terms of earlier direction, Lord, I filed my complaints, Lord, and in terms of my Lord's order,
Where is the complaint?
Where is the petitioner?
Lord,
Compliance report, we can achieve.
Did you serve the compliance report? Yes, Ms. Shaha. Please unmute yourself.
Unmute with the.
Yes, please.
Your Lordship, today morning only we have received the opposition, your compliance, Your Lordship. The compliance contains 77 pages, Your Lordship. I have to confirm the document with my client, Your Lordship. I'm praying for time for the hearing of the matter, Your Lordship.
Well, not hearing, you just check up whether the order has been complied or not.
Yes, Your Lordship.
Then
I have
come
to
back.
confirm the document.
I also insist, my Lord, because this is with regard to the medical reimbursement, my Lord. They have verified the bills based on which how the mode they have verified. Let the other side will verify, my Lord, and intimate us also if anything calculation part it is done.
All right.
Notice are there, we will pay it, my Lord. That's not an issue, my Lord.
All
As
right.
Lord's orders.
Please come. Compliance report filed in court is taken on record. Stop. A copy of the same has been served upon the learned advocate representing the petitioner. Stop. The petitioner seeks time to revert with instruction. Stop. On such prayer, release the contempt once again on in the middle of January.
Yes, no problem.
10th of January.
Your Lordship.
2026. Stop. It will be open for the petitioner to intimate the contemners if any discrepancy is found in the calculation provided in the affidavit of compliance.
Yes, in terms of the page number, my Lord, I just indicate. As page number 74, my Lord.
Yes, last page, last two.
In terms of page 74
Yes,
of the affidavit of compliance.
Yes, ma'am.
All right then.
Oblige, my Lord.
Oblige, Your Lordship.
Not there.
Yeah.
Item number 1.
For the petitioner.
I'm for the respondent number 1. No, contender 1.
Order complied?
Not yet, ma'am.
Not.
Order is of my lord 1st October 2024.
Not been complied?
Yes, Lordship, it has already been complied with. I have
Why is the
submitted.
petitioner saying no?
And moreover, the contender has already resigned from the post of chairman,
So
and another new incumbent has already joined.
No, my lord, he is still the councillor ward number 1. And my lord directed the board of councillors to consider the representation.
Board of councillor, not
all right. Where is the compliance? Let me see. Affidavit of compliance?
No, Lordship. Yesterday they served the copy upon it. Yes. 28/11.
So today is 4th of December.
Then Lordship kindly give 2 days time so that I can show that compliance has been made.
What is your instruction about compliance?
Regarding compliance, my client instructed that during his tenure, compliance has been made.
What is the compliance? Only making submission will not do. Show the compliance. Has any hearing been given?
No notice has been served, madam.
No notice also has. What type of compliance without a notice? I'll direct your client to remain personally present in that case. The entire board is over here. Just imagine what's going to happen. What is your submission?
Then we give 2-3 days time so that I can take instruction in the meantime.
Under which ward does your construction, unauthorized construction fall?
2, ma'am.
2?
Ward number 2, ma'am.
Who is the chairman now?
Now Utpal Bhaduri. Three.
Code number 13.
30.
Please come. Learned advocate representing the petitioner submits upon instruction that the order of the court has not been complied with till date. Stop. It has been submitted that no notice whatsoever was served for compliance of the order, which was passed way back on 1st October 2024. Stop. Learned advocate representing the contemners.
No, not all contemners. Only Apun Shah.
One.
Only one.
What about the others?
Others don't have.
You do not have any instruction? You served upon all?
Yes, madam. This affidavit service in the record, madam. The last occasion, madam, directed to serve Mr. Devashish Mukherjee.
Yes, because he represented. Who represents the municipality now?
Now represented Mr. Pritam Das, learned advocate representing the municipality. After Mr. Utpal Bhaduri being appointed as a chairman, Mr.
I saw your name. That is the reason I directed the service of copy upon you.
When Mr. Shapun Shah was the chairman, I was representing the entire Mal municipality.
কি বললাম? Learned advocate representing the contemner number 1, comma, the erstwhile chairman of the Mal municipality submits that the order of the court has been complied with. Stop. There is, however, nothing on record to suggest compliance of the said order. Stop. It has been brought to the notice of the court that currently Mal municipality is represented by Mr. Pritam
Das,
learned advocate. Stop. Let since the contemners were served and none entered appearance, accordingly, let a notice be served upon Mr. Pritam Das, learned advocate, intimating that the matter will appear in the list on 22nd January 2025. 26. Stop. An affidavit of compliance by the contemner number 1 and the other members of the Board of Councillors of Mal municipality shall be placed before the court on the adjourned date with a prior copy upon the learned advocate representing the petitioner. Keep this notice on record. Keep this notice on record.
To your lordship and for the my lord, the petitioner, the violations of your lordship's order in the earlier occasion, my lord.
Yes, Lordship.
I have served to the
Lordship, I on behalf of the LS Contemner 1, Lordship, I have just now the affirmation of the complaints report affidavit, Lordship. I could not serve the petitioner, Lordship.
My lord, I served to the contemner directly. My lord, thereafter they did not appear. So your lordship, please to direct me to serve the advocates for this writ petition. Served, my lord. This is the affidavit
Lordship
of service.
already, the order is already complied with, Lordship.
Are you aware of compliance?
Nothing is there, my
Lordship
lord.
already,
One month submission. My lord, I have served on 24th of November of this November, lordship. And service. My lord, if it has been complied as per his submissions, my lord, let them file a compliance report, my lord, in the form of
Yes, prepared. He says he has prepared it.
but in the form of affidavit.
Yes, yes, certainly.
already affirmation, today I affirm it, Lordship.
Today you affirmed.
But I
Please
could not
pass on a copy to your learned friend.
send the, yes, Lordship.
You could have sent it through
Lordship.
the soft copy. You could have sent. Please come. Learned advocate for the petitioner asserts that the order of the court has not been complied with till date. Stop. Learned advocate representing the contemners submits that
Only contempt number one, Lordship.
There are two contemner respondents, lordship.
ADM.
Yes, Lordship.
Who will be the appropriate authority? The ADM.
Directions upon both the contemners, lordship. If your lordships kindly see
Who-
your lordship's order.
Who appears on behalf of the Darjeeling Improvement Fund?
But if you read lordship, the state
Lordship
the
is state, Lordship. Lordship, then contempt, Lordship.
Yes.
From the order of the writ petition.
Right. In that case, you will represent both.
Lordship, Lordship. Lordship.
কি বললাম? Contemners submits that the affidavit of compliance has already been prepared and affirmed, but the same could not be served upon the learned advocate for the petitioner. Stuff. It has been submitted that a petitioner stuff. Let the affidavit of compliance be served upon the learned advocate for the contemner immediately. Stop. Release the matter for further consideration on 22nd January 2026. Stop. It will be open for the petitioner to file exception to the affidavit of compliance, if so advised. Affidavit of service is taken on record.
Lordship, kindly grant me liberty to file the compliance report before the circuit bench department.
All right. The
Lordship.
affidavit of compliance be filed before the circuit bench at Jalpaiguri.
Grateful, Lordship.
Copy will be given to you.
Lordship, Lordship, immediately. Today.
3. Dismissed. None appears on repeated occasions.
Procedurally matter item number 4.
Let me see.
Procedurally matter item number 4.
Let me see the file once. Same order. Dismissed. None appears on repeated occasions.
Application item number 170.
Till date, my lord, they have not compared your lordship's order, last order, whereby, my lord, your lordship directed them. My lord, your lordship kindly see your lordship's last order.
Where is the Howrah Municipal Corporation?
What is appearing?
Why?
I don't know, my lord. And your lord, against your lordship order, they preferred an appeal on the last occasion. I submitted before your lordship. And the division bench, my lord, observation is, I have handed over before your lordship kindly see.
What the division bench has observed?
My lord,
HMC will carry out the such and such.
my lord, may I read the division bench?
No, I have read
Yes,
it.
yes. I have,
Please see if Mr. Banerjee is there outside. I'm passing it over. Call him. Next.
and till date, my lord, they have not demolished
Oh,
after.
call him. Call him.
171.
Item number 171 on appear for the alleged contemner.
But your lordships on the last occasion are directed for filing of an affidavit of compliance. But I have the compliance with me, my lord. I was praying before your lordships for some time for filing the affidavit. My lord, your lordship's order was, my lord, to take a decision with regard to the unauthorized construction. The Panchayat authorities, but I am the Pradhan of the Panchayat.
Yes.
But I have taken, we have taken the note of everything. They were served, all were present, and it was found that there was an unauthorized construction. We have taken the records to the subdivisional officer under section 23(5). I have the records with me. We suggest that, my lord. My lord, I was
Suggest that
we have, my lord, forwarded the records of this case to the subdivisional officer who is to take the final call, my lord. My lord. It is a belated act, my lord. I admit, but it has been done pursuant to your.
Are you aware? Hearing?
Yes,
Yeah.
was done.
Yes,
You
they
have
were
taken
present.
decision that decision was communicated to you. But so far, recommendation before the
Recommendation.
But we have the report also. It is that my lord, I need to have it found.
23 order.
Yes.
And you are complying in 25.
My lord, this is the belated action, my lord.
All right. How much cost is to be deposited?
My lord, I
10,000?
I cannot say, but only I can say this, my lord, that the order probably is being compliant with. We shall take all endeavors to have it
Yes,
done.
please do, and pay rupees 10,000.
Lord, I leave it up to your lord.
Yes.
The order is this, my lord. It has been found that both the petitioner as well as the private respondent is, my lord, has made.
Take steps, sir. Why are you sleeping?
My lord, it is.
Years.
I understand that, my lord.
Aligunta? Learned advocate representing the contemner submits relying on the communication made by the Pradhan of the Gram Panchayat dated 26th November 2025 that the issue of unauthorized construction has been considered by the Gram Panchayat and the file has been forwarded to the subdivisional officer for passing final order in the matter. Stop. It has been submitted that unauthorized construction has been detected. Stop. Next. Learned advocate for the petitioner has not been made aware of the steps taken by the Panchayat. Stop. Next. In view of the above, the above hearing of the contempt application stands adjourned till 8th January 2026. Stop. The an affidavit of compliance shall be prepared and served upon the learned advocate representing the petitioner prior to the adjourned date. Stop. As the order of the court has been sought to be complied with nearly 2 years after the same was passed, the court thinks it fit to direct the Panchayat, not the Panchayat, the Pradhan of the Gram Panchayat, to pay a sum of rupees 10,000 in the office of the Bar Association, High Court, Calcutta, and produce the receipt of payment before the court on the next date of hearing. Take this back. I'm giving it to you. Prepare the compliance and serve.
Item number 172.
1 minute. Where is Mr. Oh, there. I was looking for you here.
I'm sorry, madam. I thought that other benches are there. For that reason, I hurriedly came.
Yes.
72 days.
1 minute, please. Yes. Has it been complied?
It has been complied. I'm saying, madam, I'm bringing the report.
Let me see.
And the G+1 sanction is there. There are deviations there. So deviations problem is this one. I've got the pictures also. Problem is that two buildings are so touching with each other. It will cause serious damage to cause serious fatal accident also, because all the buildings will then fall. So, my lord, if your lordship so desires that all the buildings may cause damage, then it is not. Special officer may be appointed to see, my lord. What is the problem? We will be there also.
How many floors unauthorized was there?
One.
My lord,
G+1 is
plus
there.
one sanction.
Construction
First
is made up.
G+2, entire second floor is unauthorized.
I have
Floor has been demolished.
have been demolished.
Only the roof. Your lordship direction.
Walls?
Special officer we said. I have heard that everything.
Your lordship specific direction was that to demolish the outer wall also. Your lordship kindly see, my lord, this is the picture. Yesterday, my lord, it has been taken. This is the picture, my lord. 3rd December picture. No demolition of the outer wall. Your lordship directed that to demolish. Otherwise, my lord, your lordship kindly see, beams are also there. No demolition of the outer
The
wall.
outer walls are still.
Yes, my lord. Now let the engineer comes and says they are enmity between two. They want the entire building.
No. See, if the second floor is completely
Yes.
unauthorized, why don't you demolish the second floor?
And why not let it be taken up next week? I will bring the engineer and I will say that what is being doing.
And the division bench also confirm your lordship's order. Kindly see, my lord.
That
It's all right. But the wall still remains.
I'm asking them to then come, my lord.
See, the pictures have been taken in such a manner so that you do not understand how the construction is there.
Then let the special officer goes at least.
Who has taken this picture?
The engineer itself.
Engineer himself.
An engineer can come also.
This is the yesterday picture, my lord. Kindly
They
see
say that is yesterday's picture. I don't know.
Uh,
If your lordship calls the engineer, I will call him. Or
report
may I
of
take it upon next week? I will come with the second floor.
assistant engineer
What is the
402
picture of the second floor?
HMC has forwarded a report signed on 2nd December 2025.
Boro 2.
अच्छा Boro 2 बोलना ना हाँ which mentions that
And 3-4 buildings are completely touching the other this building. If anything done, that will cause serious damage to the damage means fatal accident may also happen. A special officer may be appointed. I also gone there because I am very much scared about your lordship. That anytime your lordship will call the engineers and everyone.
अच्छा की बोललाम which mentions that the having their outer wall as well as the foundation or that the outer wall as well as the foundation are in common with the adjoining building.
In four sides, all the buildings.
My lord, this is the last report. And my lord, prior to that, my lord.
Further demolition may cause serious damage to those buildings.
And it's an old building, madam. Man sees that it's an old building.
Yeah.
Stop. The
newly
building has a sanctioned plan up to the first floor level, but the construction has deviated from the sanctioned plan. An unauthorized construction of the second floor has already been demolished. There is no front, rear and side space left. So, the portions which have been deviated is very difficult to demolish.
যান কোর্টকে মিসলেট করে
সোশ্যাল অফিসার বললাম
আপনি তো মিসলেট করছেন
আপনার
Paragraph. The petitioner as well as the Howrah Municipal Corporation has placed photographs in support of the submission that the unauthorized floor has been completely demolished. No, has been demolished. Stop. From the photograph produced by the petitioner, it appears that though the roof of the second floor has been demolished, but the walls still remain. Stop. The assistant engineer Boro to Howrah Municipal Corporation is directed to remain virtually present
he will be physically
on
no problem.
8th January 2026.
He will be physically present.
Stop. The corporation shall proceed to demolish the outer walls as far as practicable prior to the adjourned date and file
What happens when
and
just placing this
file a
adjourn
further
for touching with the
report
buildings?
before the court. You say touching. Look at this picture.
Let me see.
Show it to him.
Yes, my lord.
Where it is touching.
And my lord,
It is not touching.
what he is submitting, I failed to understand. He said that this is old building, new construction, my lord.
I will come.
Now he said
It is not.
and
Let a copy be given to me.
and my lord, more, one thing more.
Copy be given to me. I will show.
My lord,
Show
yes,
the
yes,
picture
yes,
so that
I
we can show it to
hand
his
over
client.
just now. My lord,
hand over আমাকে করুন না, আমরা তো আসি।
and my lord, one thing I have to submit, my lord. My lord, your lordship direction was entire unauthorized construction, so far the top floor is concerned, and the deviated portion of the ground floor and the first floor. Now, my lord, kindly see it. No demolition of the deviated portion. Result is, my lord,
I remind me on the next day. I'll speak to the engineer.
deeply of this, man.
Let him
Deeply of
make his submission.
deeply of my lord, I am handing over a copy.
Yes.
Yes, I will give them a copy. Immediately. Well, virtually or physically also he can be present, man.
I have no problem. He appears
I will
virtually.
call him physically. Let them come.
I'll deal with him appropriately. Next.
Deviated portion, my lord, untouched.
172, my lord, I am for the petitioner, my lord. My lord, kindly see the last order, my lord, filed by your lordship, paragraph 4, my lord.
Yes.
Direct the municipality, direct the
Chairman of the Garulia municipality.
I appear for the municipality, and after the order was passed, another further payment of rupees
1,20,000.
1,22,800.
Payment you are made, there is no dispute.
Yes.
Only dispute is, my lord, that PPO, my lord, last officer, my lord,
It
it was handed over to your lordship, my lord.
Yes.
That PPO was wrongly with effect from date of joining, my lord.
Right.
Lordship,
This is fine.
Lordship, I have
It should have been from which date?
Lordship, or I have received it on phone. Lordship, that's why. She was appointed in 1/1/1986 and was as a casual employee till 28/2/2006. So the calculation starts from 2006 when the service was regularized and as a permanent.
Why will he not get the benefit of the prior service?
Because on a casual, her appointment was on
What was the direction of
casual.
the court?
Page 23 of the rate petition, my lord, can it undo?
No, how was it disposed of?
My lord, page 23 of the rate petition, my lord. First paragraph, last line, my lord. With effect from the date of joining such post, my lord. That is letter of approval, my lord.
Page 23.
Of writ petition.
With effect from the date of joining.
Yes, first paragraph, last line.
Yes.
And that approval was issued, my lord. 53 employee, my lord. Total 60 number of employee, casual employee was forward.
Listen, I think you are required to file a fresh writ petition because you have to challenge it by way of a fresh writ petition. Is there any mandatory order of the court that you have to be regularize
Paragraph
or
six of the report as stated.
paragraph 6 will not do. The court's order is
Page 25.
to direct the authority to compute the terminal benefits, including pension.
Yes.
Lordship,
So there
can
is
I?
no order that the past service has to be taken into consideration.
Stated all these things in my writ petition. They did not raise any dispute at the time of hearing, my lord. Municipality appeared.
I
Not
understand.
only that, my lord. Kindly see my representation. Page last page, my lord, page 28.
Please come. The petitioner seeks terminal benefits. Stop. It appears that the service of the employee was regularized from 1st March 2006 and PPO has been issued from the said date. Stop. According to the petitioner, the employee was employee joined service in the year 1986.
1186.
1st January 1986.
As casual employee.
Accordingly, he ought to be provided benefit on and from the said date and not from the date of regularization. Stop. Next. The court is of the opinion that the issue as to whether the PPO has been issued from the proper date or not cannot be looked into or adjudicated in the contempt application. Stuff. In view of the above, the contempt application stands disposed of. It will be open for the petitioner to challenge the action of the respondent authority in issuing the granting the terminal benefit from a later date. Contempt disposed.
Grateful, Lords.
Number 173.
Yes.
I appear on behalf of the alleged contempt.
Yes.
I appear on behalf of Ms. Malvika Rai for the petition.
Has not been.
Complied.
Has been.
I have that instruction.
Has been complied. Disposed. Complied. Yes.
Item number 174.
As per your lordship direction, I have served the copy of the contempt application upon the alleged contempt. Now kindly see, my lord, page 15 of my contempt application, your lordship's order.
Who is the contemptor?
Video.
Video. None appears on behalf of the contemptor despite service. Step. Contempt rule. Returnable on 29th January 26.
What a rule to be served by special messenger course to be deposited.
Yes. Next.
Item number 175.
Well, in this matter, I am for the petition. As per your lordship's earlier direction, my lord, I have served the copies. This is my affidavit of service. They have received. Before going to the records, my lord, your lordship can just bear me.
Order has not been complied. Not complied.
Nothing. Yes, only they are taking step. Your lordship, our allegation was twofold. Unauthorized construction, unauthorized encroachment. Your lordship directed two authorities to investigate and to take step for removal and demolition. Now only the letter is being issued that investigation will be made. Investigation will be made.
But nothing is happening.
Nothing is happening. This is I have annexed all.
Give a copy to him. This is February 25.
I'll kindly see page 3, my lord, last portion order.
There is no other encroachment. আমাদের notice দি
Has this been communicated to the
no,
petitioner?
nothing, no notice, nothing of the sort.
Make an order and you keep it in your records without communicating. How will the petitioner get to know?
No notice, nothing of the sort.
No notice was issued.
No, no.
It records that the petitioner made representation and there is a direction for service of notice. Both parties put up hajira. You say no notice was issued. Please come. The petitioner complains of violation of the order passed by the court.
Let them file affidavit, my lord. Let them deposit by filing affidavit.
Learned advocate representing the. Who are you representing? SDO?
SDO.
The subdivisional officer, Bushirat, North 24 Parganas, relies upon the order sheet dated 17th February 2025 to 28th February 2025, wherefrom it appears that the order of the court was duly considered and the same stood disposed of. Stop. There is nothing on record to suggest that the order was communicated to the petitioner. Stop. Next. A copy of the said order has, however, been handed over to the learned advocate representing the petitioner in court today. Stop. The petitioner appears to be aggrieved by the order that has been passed. Stop. Paragraph. The court is of the opinion that the correctness and validity of the order cannot be adjudicated in the contempt proceeding. Stop. The instant contempt application stands disposed of with the observation that it will be open for the petitioner to challenge the order passed by the authority before the appropriate forum in accordance with law, if so advised.
Without disposing of. Your Lordship, first two, my lord, the order, there is a two limb of the order. One, unauthorized encroachment. It was directed for investigation and to take step by the PWD department. And another, my lord, unauthorized construction, which is to be investigated and to be ordered to be passed by the SDO. These are the two, my lord, the limbs of the order. Now the SDO has come, my lord, appeared before this court by submitting this. With regard to the PWD department, what your lordship directed, your lordship come, your lordship's order.
You come to this order. It mentions that the ordering portion that.
Yes.
After going through all relevant evidences, it is concluded that there is no unauthorized encroachment over the government land in front of such and such.
But your lordship, where is the report of the executive engineer?
Yes, that means you are not aggrieved. You are aggrieved and you are not happy.
No.
It's better you challenge it and get things done. Service taken on record.
Your lordship, where is the findings of the executive engineer?
On that ground, get it set aside.
I am for the petition.
Yes, what is it?
Last occasion, your lordship directed me to serve the notice. I have served. This is my affidavit service. They have received.
Who is your other side?
The order, kindly see the order, my lord.
Who is the respondent?
Respondent, my lord, Abhijit Sarkar and Orijit Sarkar.
Pradhan of the Gram Panchayat.
Yes. Late contemner is my lord.
Yes. Unauthorized construction. Nothing done.
Nothing.
Rule 29th. Next.
177.
177, my lord. I am appearing on behalf of the contender, my lord. My lord, I am for the petitioner.
Has the order been complied?
My lord, what are those twofold order? My lord, kindly see the impugn order.
Not complied.
As because, my lord, rescind order has been passed, my lord. That rescind order has been challenged by writ petition and by a order of under an appeal under section 218(3) has been preferred, my lord.
Before the civil court?
Before the civil court.
Are you aware?
I am aware.
Yes.
My lord, kindly see the impugn order, my lord. Kindly, please. In my contempt application, my lord, page 19.
Yes.
My lord, kindly see, in compliance of the direction passed by this court, a joint inspection, spot inspection was conducted in the presence of the parties. The report of joint spot inspection has been filed in court. Read copy of the same circulated amongst the parties. It appears from the report that the unauthorized construction by encroaching the government land, PWD, has been detected. The Board of Council of Conta Municipality has mentioned that the municipal authority is not custodian of the land and as such does not have any right to demolish the unauthorized construction. The report of the municipality mentioned about a civil suit is pending, which is pending such and such. As it appears from the report filed by the official respondent that the government land has been encroached upon the private respondent by making unauthorized construction. Accordingly, the official respondent, that is PWD Road, is directed to take necessary steps to deal with such unauthorized construction in accordance with the law. Well, that part till pending. PWD.
Okay.
PWD.
Who are you? Municipality?
Municipality.
Did you communicate this to
yes,
PWD authority?
Yes, my lord. My lord, kindly see page 5. Mr. Kartik Chandra Das, the executive engineer, PWD Roads, Government, West Bengal, and Mithun Raul, the assistant engineer. My lord, I am service upon the that
inspection to হয়েছিল
হ্যাঁ PWD কোনো স্টেপ নিচ্ছে না, ভাঙতে যাচ্ছে না, কিছুই করছে না।
Page 5.
মানে in my contempt application.
That is the cost title.
That is the cost title. One is the chairman.
Respondent number 3.
2 and 3.
Executive engineer and the assistant engineer.
That part was not done.
Please.
Rescind order was passed, then against the appeal, before the writ petition, one after another
has been submitted by the learned advocate for the petitioner that the direction passed upon the Public Works Department has not been complied. Department in the order dated 2nd January 2024.
Yes.
Has not been complied with till date. The PWD within bracket roads. Stop. The matter relates to removal of unauthorized construction, which has been made by encroaching upon the government land. Stop. Next. The let notice be served upon the non-appearing contemners, intimating that the matter will appear in the list on 29th January. An affidavit of compliance shall be filed by the contemner numbers 2 and 3. Let this order be communicated to the aforesaid contemners forthwith. Stop. As regards the contemner number 1, the petitioner does not have any allegation.
Allegation, but he is not demolishing. He is not till date. He is not demolishing without.
Then you say he says that he has taken.
Only, no, on his part, private land. It is unauthorized without sanction plan.
On his part, there is an order of the civil court.
What order was passed? This is unauthorized construction. Demolition with.
Then the civil court is there.
Civil court. That order be challenged.
Yes.
Without stay.
So what? As regards the contemner number 1, no further order is passed as it has been brought to the notice of the court that the order of demolition which was passed has been challenged by the aggrieved party before the competent forum, and the and the appeal is pending consideration. ঠিক আছে?
And my lord, next date fixed on 15 December 2025. আজকে কত?
Next.
এই তো যা।
Number 178.
একটা প্রিন্ট আউট নিয়ে রেখে দিতে হবে।
According to it is appearing for the petitioner lordship. He didn't claim to be due to severe illness, lordship praying for not to.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Step. Release term 15th of January 2026.
এরপরটা কত আছে? 179. I'm for the petition. There is a willful violation of your lordship order dated your lordship 28th of February 2024. Appearing your lordship page number 28. So allegation is your lordship that the unauthorized construction that was being carried out by the private respondent. Lordship was pleased to pass a direction upon the respondent, the state respondent, the municipality, to consider the representation by the petitioner within a period of your lordship 3 months from the date of the order.
Who's appearing for the municipality? Which municipality? Modhamgram.
Yes, lordship.
Show me the service of the order upon the municipality.
Yes, your lordship. Kindly come to the page number 22, your lordship. 22 is the lordship communication the order. And after that, your lordship, municipality asked me to appear. They have conducted your lordship hearing. I went there, your lordship. I submitted the documents as per the requirements. Despite your lordship, they have not culminated their proceeding.
It has started but not concluded.
Yes, your lordship. The notice is your lordship, appearing in page number 33.
23.
33 and 34.
23. Please come. The order of the court dated 22nd February 2024 has not been complied with till date. Stop. None represents the Modhamgram municipality despite service. Stop. Affidavit of service is already on record. Where is your affidavit of service?
Since I have not served the copy to me.
Huh? There no order of service. Unappears বলছেন তো। হ্যাঁ, এটাই তো ফার্স্ট টাইম তো অর্ডার নেই তো। Let a copy of the contempt. এটা তো non appears. Let a copy. Copy be served. First day order করে দিন। ওটাকে করে দিন আপনি 29th of January. Serve.
Your lordship, order dated 28, not 22nd.
কি বললাম? All right, serve.
Yes, sir.
Item number 180.
I am for the petitioner lordship. I am not in I am not in contact with the client at present, lordship.
They will not be in contact with you. Already demolition has been done.
Lordship may be pleased to direct the matter out of the list with liberty to mention.
Material instruction not. Maybe for further. But we have contact.
Achha, learned advocate for the petitioner submits that her client is not contacting with her.
But 1.5 months the demolition has been done.
Stop. Learned advocate representing the contemner relies upon the instruction forwarded by the Assistant Engineer in Charge, Building Department, Howrah Municipal Corporation, signed on 25th June 2025, mentioning that the that most of the unauthorized portion of the unauthorized portion has been demolished. Stop. Next. As it appears that the petitioner is not taking steps to proceed with the contempt application, accordingly, the contempt application stands disposed of. The report be retained with the records.
181, my application, my lord, I have served upon the alleged contemner, my lord, filed affidavit of service. My lord, order dated, my lord, 8th September 2024, that will appear at page 9, Annex P. That has not been complied with. Simply communicating a letter, my lord, by the alleged contemner, will page 15. Your lordship will see. No steps taken, no followed up action.
You go before the civil court and get it done.
My lord, because the tamarind tree is damaging my house building there, my lord.
Yes.
And that's why your lordship was pleased to direct the authority concerned, the concerned Pradhan. My lord, page 19.
Pradhan will not be able to do anything.
My lord, she is to inquire into the field, my lord, and to take steps on the basis of that. Your lordship's order, my lord, page 9.
I can see.
Followed up action has not been taken. Only trimming of branches of the tree. Nothing else. I am not, in respect of my lord, cutting down the trees, my lord, there. My roof is totally damaged. And earlier order was passed by this court also, my lord. To that aspect, my lord, I have made all aspect, my lord. Delivered.
And then Anna appears on behalf of the contemptor.